Welcome, everybody. I know it was a short night for a lot of you, and just again appreciate the committee's work and also LSO. Looks like Tanya's not here, but I know the rest of you. Okay. Well, gosh, I guess I should have waited for her to get back. But in the meantime, just wanted to say thanks to everyone because it was a long night but it was I think we got a lot of work done, a lot of good work, and appreciate all the folks that were able to testify. That's what we always want to hear is from the public and make sure that we're on the right track with what we're doing. And so today it's I don't think it's going to be as big a lift. I don't think our agenda is quite as full, but we'll see. We're going to try and stay on the task as best we can. And our first guess now that Tanya's here and Ashley's here, we can get started right away. We're going to start off with charter schools. Unless, do you have anything, Co-Chair, that you would like to say? Okay. We're going to start with charter schools, and our first bill up for consideration today would be 25 LSO 0194. And I think we'll just dispense with roll call if that's all right. I don't think we need to today. So hopefully Ashley and Tanya can get us started with that. Welcome back. How did you enjoy your short night?
Madam Chair, members of the committee, Tanya Heitrick, Operations Administrator. The one thing I do want to clarify for members of the committee at the outset is Ashley is a paralegal. She's not representing that she's a lawyer. She's practicing under my license. Just want to make that clear. In the event that you have questions, legal questions, constitutional questions, I would ask that you direct those to me.
Madam Chairman, members of the committee, Ashley Phillips, Legislative Editor, LSO. Before you have 26 LSO 194, Review of Charter School Applications. You may recall at your last meeting in August, the committee directed staff to draft a bill that incorporated amendments brought by the Wyoming Charter School Authorizing Board. So that is precisely what this bill does. It's pretty straightforward, amending Wyoming Statute 21.3.307B and 21.3.308A. So on page 2, with subsection B of 307, it simply eliminates the timeline for determination to the timeline for the charter school, for the authorizer to determine if the application submitted is complete. It was 30 days. Now it is however many days the authorizer needs. A little further down, line 10, 21.3.308A. On line 14, it eliminates the timeline to hold public hearings. So those can be held anytime after submission and after determining the application is complete. And then finally, on page 3, line 6, it increases the timeline to approve or deny an application from 90 days to 120 days. So under that, the whole process, start to end, is limited to 120 days. It would be, you can see on the staff comment, lines 16 through 24, this bill does not amend Wyoming Statute 21.3.305F, which requires the authorizer to make a final decision on renewal of applications not later than 30 days after the charter school files a renewal application. This was not included in the bill drafting instructions, so it's not included in the bill draft. And then finally, well, not quite finally, on page 4, lines 1 and 2 in section 2, this act shall apply to new charter schools submitted on or after July 1, 2026. And then the act is effective July 1, 2026. And then the final thing for real is that this, as amended, still applies to all charter school applications, not just those submitted to the state authorizing board. So it's school districts and the state. And with that, we'll stand for questions.
Any questions? Yes, go ahead, Senator Moffett. Senator Scott, we'll go Senator Scott first.
Uh,
Madam Chair, Senator Scott, you're correct in your interpretation. It is a quicker timeline for renewal applications. And as far as the practical implications of that, I'm sure that the charter school director is much more well-versed in how that might affect them. These changes did come from the Charter School Authorizing Board and their executive director. We don't have an opinion on how this might affect that process.
Senator Rothfuss.
Thank you, Madam Chairman. So my understanding then is that the clock starts, so to speak, with these changes, the clock starts upon submission. So that would incorporate the B paragraph, which currently talks about completeness, but that is an application submission. So B paragraph is included in the clock. The A paragraph at the bottom of page 2, that 60 days is included in the clock, and then the total clock becomes 120 days, as I understand it. So everything that previously had a few steps in this amount of time and that amount of time is now all incorporated within the 120-day window. Is that accurate?
Madam Chair, Senator Rothfuss, it is.
Okay, thank you.
Senator Scott, do you have a comment or a question?
yeah, Madam Chairman, this question.
Also, do you have any?
Madam Chair, Senator Scott, we don't have comments on that. I would defer to the Wyoming Charter School Authorizing Board Executive Director. I saw Mr. Waller here in the audience, so perhaps when we're done presenting the bill, you can call on him.
Other questions from the committee on this bill? Okay. Thank you so much. Guess we'll open it up for public testimony and maybe we'll get some answers to those questions. I see someone here. I see somebody that might be able to answer some of those questions that we have. Welcome, and even though we might know you, please introduce yourself.
Thanks for the opportunity to speak with you all, Madam Chair and committee. My name is John Waller, and I am the Executive Director of the Wyoming Charter School Authorizing Board. I'm here to reinforce my support for the proposed changes to the charter school legislation, LSO 194. The intent behind these amendments is to enhance the effectiveness and integrity of the charter school authorizing process while preserving the transparency and accountability expected by the public. By slightly retracting the application window, the review period will be extended, providing authorizers with additional time to evaluate submissions without affecting applicants who still have ample time to prepare for school opening. As I pointed out in September, a couple of key objectives. First one is increased flexibility for the authorizers. The amendments remove overly prescriptive language while maintaining core requirements. This will allow us to carry out our responsibilities more effectively within our available resources without compromising the overall timeline. It's an extended review period. By lengthening the review period, authorizers have the necessary time to conduct more thorough evaluations and facilitate meaningful discussions with applicants. And then structural flexibility. The revisions introduce a degree of flexibility within the framework of the authorization process, enabling authorizers to tailor procedures as needed while still meeting the requirements. These revisions are critical to the mission of thoroughly vetting charter school applications to ensure that approved schools are academically sound, operationally viable, and aligned with the needs of Wyoming students and communities. So at that, I would be happy to entertain any questions from you. I hope I have an answer. I want to make sure I understand yours, Senator Scott.
Excuse me, go ahead, Senator Scott.
Yes.
Madam Chairman, and what I'm trying to find out
Mhm.
is between now and the end of the general session,
Mhm.
March, a year from, not the coming March, but March a year. What workload do you expect in the way of new applications? And what I'm looking for is if the workload isn't too bad, we might be able to save this bill for the general session.
Mr. Waller, go ahead.
Yeah, Madam Chair, Senator Scott, the workload, I think indications are that we're going to have quite a few applications coming forward this year. And so I think I'm gonna have even more gray hair when I see you guys next. I think it's gonna be quite a big year for vetting those and holding our meetings. So if I understand your question right, you're saying, could we put it forward? Could we wait a year to then do this? I think our preference would be to get this in place sooner. It won't impact this year because it doesn't go into effect till July, but I think our preference would be to do it sooner than later, but I don't know all the dynamics behind that.
Go ahead, follow up.
Madam Chairman, are you talking 3 applications? Or are you talking 20?
That's the $1 million question. We're actually gonna, in early January, we're gonna send out an intent to apply form, and hopefully folks will fill that out to let us know, we're looking at, my best guess right now would be between 3 and 6 applications will be coming forward, which would, when we're at 4 schools right now, so that would be a pretty significant raise there. That's just an estimate from talking to folks, but hopefully we'll have a better idea. In January, we want to send that out, hoping people say, our intention is to apply, and so we can get ready for those to come in.
Other questions? I just have one, Mr. Waller, your board, I assume you're kind of scattered all over the state. Can you talk a little bit about your board and where they get together and how they get together and how they review these applications?
Yeah, well, what we'll do in this March timeframe, we take that month of March, and that's when we're collecting those applications. We're making sure they're complete. The first step is to be complete. Then we'll start analyzing those with a rubric, and we're going to train folks to help with that process. And then we start into the meetings in the different communities, the really important part right there. And so while we do have a board spread out all over the state, we have toyed with the idea of just to hold costs down. Do we just send a couple representatives and the others join virtually? I would say, speaking for the board, it's really important to this board that we are out in those communities and hearing from them. So we're really trying to hang on to that. I think it's so important that we get to know, is this really important to you and why, and what's your plan? And so it's in the discussion stage right now. Do we do a hybrid of that? But if at all, our preference would be that we could all attend those meetings and all hear from the committees. So, yeah.
Any other questions from the community? Oh, go ahead, Senator Olson.
Thank you, Madam Chairman. Earlier when you were discussing with Senator Scott, you mentioned the July 1 effective date.
Mhm.
Is that the optimal start date for this legislation, or would you prefer an earlier start date? How would that affect those applications coming in?
Mr. Waller?
Personally, Madam Chair, Senator Olson, I would prefer the earlier the better, because I know we've got a lot coming in. I want to do a really good job with these applications. I don't know if we could get it. I don't know the dynamics behind, your work, but sooner would be better for me and for our group than later. It would.
Yeah, Madam Chairman.
Follow
Yeah,
up?
from what we can do with the legislation is July 1's kind of just the default provision,
Mhm.
but we can make it effective immediately upon
Okay.
becoming an act. So if it is passed and if the governor does sign it into law, then it can go into effect at that point in time. So that
Okay.
would be the end of our session. So you'd be looking at an early spring start date instead of a July 1.
Oh,
start date.
man, that would be wonderful if we could do that. That would really help, I think. Thank you, Senator.
Thank you.
Other questions? Representative Lawley, did you? Oh, you weren't. Okay. You're just waving at me. All right. Senator Scott, another question? Go ahead.
Yeah.
Mhm.
Madam Chairman, my question. How many applications are you allowed to approve? Is there still a limitation on those in this coming year? Has that come off?
Mr. Waller?
Madam Chair, Senator Scott, at this point, there are no limits. Anyone who wants to apply can apply this year, so.
Any other questions? Okay.
I do believe Janine Bateski wanted to.
Oh,
is
certainly,
online.
yeah.
Am I correct?
Is she online right now?
Yes, Madam Chairman, she is.
Okay, let's go ahead and bring her in since we're on the topic. Good morning, welcome, and I think you're muted, but please introduce yourself.
Am I muted? It looks like I'm not.
Now you're okay. Go ahead. We can hear
I'm
you now.
Janine Bateski, and I am the chair of the Wyoming Charter School Authorizing Board. And first of all, I want to thank you for your work on this because this is really, I think really opens things up and allows a little bit more flexibility to do a good job in approving these applications as they come forth. And I especially want to thank Senator Olson for his question as I've been sitting here thinking about it. I think it's really, really important. I think that we open up this window for this for this application cycle, which begins in March. We don't know, Senator Scott, we don't know how many applications we're going to get. What we do know is it appears as if there might be some pent-up demand that is going to surface as a result of there being a moratorium on the number of schools that we can open. And so I just want to make sure that the board and the folks that we're using to help evaluate these applications have plenty of time to do this. Just to let you know, when we received the last two applications, as you opened up the one spot was to approve one application. Those applications came in, one of them was 450 pages and one of them was 180 pages. So this is not for the, it takes a lot of time and a lot of effort to do a good job in approving these. So anything you could do that would assist us in that would be very, very helpful. And in terms of Senator Schuler, Chair Schuler, you asked about our meetings. We generally meet via Zoom once a month. This past year, I think we met twice in person. And it's certainly not optimal, but it certainly helps keep costs down as well as allows all of us to participate across the state. Because I think representation across the state is really pretty important. So I'll stand for any questions you might have of me.
Questions for Ms. Bateski? I have just one. The process, it sounds like, is quite rigorous. Have you guys thought about taking a look at your application process? It just seems like if you're having to look at 400 pages of whatever it is that you have in that process, maybe have you guys thought about redoing that, taking a look at it, changing that at
Well,
all?
Thank you, Madam Chair. Yes, we have. In fact, there has been a committee that's been working on that. It's difficult though, when you want to do a thorough job is, how do you make sure that what we're doing is going to end up in successful schools? Because in the end, why are we doing this? We're doing this for the students of Wyoming. And the last thing we want is to approve a school that really isn't going to get off to a good start and be able to meet the needs of the students in that community. So our Our executive director, Mr. Waller there, has been working with an application committee, trying to put rubrics together, which might help to simplify things, but there's still a lot that has to be done to evaluate the aspects of things.
Yeah, and then
Yes, Mr. Waller?
Madam
Yeah.
Chair, one thing we're looking at, and I think we're probably going to pursue this, is a new idea of moving things to, you call it a year zero agreement, take them out of the application. They're things you accomplish in that year before you open. And so I think that may help just a little bit. And I'm actually picking out quite a few things right now that could be part of that. You're still accountable for those things, but almost like a checklist for before we start our school, these are the things that need to be done. So that's one thing we're looking at, because yeah, it's quite a process going through these applications. So yeah.
Comment? No?
Madam Chairman, comment on this, having been somewhat involved in the Casper one. It's complicated enough so that in your larger districts, where you're dealing with what's going to be a larger charter school, you're very likely to early on get tied up with some people from out of state whose business is establishing charter schools and running charter schools. And their experience is one of the things that drives the size of the application. They know what needs to be covered, so that you are, because you're essentially negotiating a contract. So I think efforts to simplify, and particularly efforts to simplify where you're dealing with a smaller district, and maybe the real problem is you got one community scrapping with another. Maybe those can be dealt with in a much more simple fashion. And I think you're going to find a certain amount of trouble with the major ones getting away from the large application.
Yeah.
I don't know what the Cheyenne experience was, but I think it was similar in that respect.
Yeah.
Senator Olson, did you have a comment?
Yeah, Madam Chairman, I remember hundreds of pages. I do remember that. I remember the charter was complicated, but we did use an education service provider in Cheyenne. So we used just like you described, a company who has attorneys and research staff that are used to producing those types of applications. So it was probably easier for us to put together than it was for the board to review. But definitely though, they're very lengthy.
May I reply,
Go ahead.
Madam Chair?
Yeah, please do.
Senator Scott, we have been advised by our attorney in the Attorney General's office that all applications, excuse me, must be the same. We can't bias based on the size of the district.
Any other comments or questions?
Madam Chairman.
Yes, Senator Scott?
I think she may have just given us a topic we need to look into, because I think the attorneys may be driving stuff that's going to make it impossible or very difficult for smaller school districts in particular, even where everybody's in agreement to participate in this. And we may lose something in the process, Madam Chairman, but that's outside the scope of this bill.
Sure. Maybe something to take a look at for the interim or topic. So other questions for Mr. Waller or Ms. Vateski? Okay. Thank you so much. Unless you have any
Thank you, Madam
parting
Chair.
comments?
Thanks for your work on this. I appreciate it.
You bet.
Thank you.
Thanks. Any other public testimony? Looks like we might have some more coming. Welcome. Please introduce yourself, even though we probably all know you.
Madam Chairman, members of the committee, my name is Brian Farmer, Executive Director, Wyoming School Boards Association. As the committee was reminded by council, there are two types of charter schools in Wyoming, state charter authorized and then district authorized. And as of today, the majority of charter schools in Wyoming are district authorized charters. So a couple of comments with regard to this. First of all, Mr. Waller brought this to us to talk about how does this impact district authorized charters? And we see it as a similar good. This bill is a similar good for district authorized charters as it is for those state authorized charters, because it provides, in essence, as Senator Rothfuss pointed out, this bill basically just provides an extended timeline with greater flexibility of how to manage the application. So with that regard, this is a simple bill. I don't believe that there's any need to withhold this bill from this session. This is one of the simplest ones you'll probably face. Easy. I don't anticipate lots of opposition to something like this because it really is about providing that flexibility. So I would encourage the committee to pass this. I think it's good for folks all around. And it really is pretty simple in what it does and what its purpose is. With that, I'd be open to any questions.
Questions for Mr. Farmer? Sir, I'm just going to say, I'm glad you brought that up. I thought about that, the difference between the district and the state authorized. And so there is definitely a difference in how they're handled. And so I appreciate that. I wasn't thinking in that direction, but
Madam
Thanks, Beck.
Chair, as a school board member, I did have the opportunity to sit through 3 of those, to review 3 charter applications. And so I personally have that experience. I know that our districts that experience it, they really do appreciate that thoroughness. And, you know, I think it would be helpful for the committee to know that there is Chapter 32 rules from the Department of Education on charter schools. So even though you have this section of statute that you're talking about, there's also the Chapter 32 rules. And Section 6 of those Chapter 32 rules do speak to the timeline. So it is Section 6, Paragraph C that says charter school applications shall submit applications to the department from March 1st through March 31st. And so that does provide that window that Ms. Bayteski was talking about when to get applications. That's how the Charter Authorizing Board knows what they're facing for the coming year. That's how districts have an idea of how much we're talking about. So those rules, those administrative rules, in addition to the statute, help provide structure for anticipating what we're going to be facing in the coming year.
Other questions for Mr. Farmer? Okay, thank you for that clarification. Welcome.
Madam Chair, Boyd Brown, and I'm speaking as Boyd Brown today, taking my other hat off. I just wanted to say that I also support this. As a superintendent, I've received applications, and I think that this gives a little more flexibility for both the applicant and then also for whether it's the district or the state charter board, to be able to meet some deadlines and stuff. So again, supporting the bill. I have been on the other side. Before I worked for WSBA, I was a consultant for probably half a year and also put in a application for a charter school with a company in Casper that was not approved. So I've been on both sides. I just think this gives us the flexibility that they need, especially not knowing exactly how many will come in. And with that, I take any comments or questions.
Any questions for Mr. Brown? It's great to hear from someone that's been on both sides of the aisle, so appreciate that. I neglected to ask if the State Department of Education wanted to weigh in. Probably should have had you guys come up first. The A team.
Thank you, Madam Chair. Dickey Shaner, Department of Education. The state superintendent does support this bill for those reasons that have been stated. It will help them deal with the lifting of the cap next year. And to Senator Olson's point, having it effective upon signature would potentially, hopefully get it to where it's effective during that March 1 to March 31st timeline for applications next year.
Questions for Mr. Shaner? Okay, thank you for that. Appreciate it. Anyone else in the room that would like to testify in the room or online on this bill?
Nobody
Ashley,
online, Madam
Nobody else
Chairman.
online?
Nope.
Okay, great. All right, with that, we'll go ahead and close public testimony. Committee, got a motion to move the bill. Do I have a second? Second, okay. Discussion.
Madam Chairman,
Yes, Senator, go ahead.
I would offer an amendment to Section 3
Okay.
to make the bill effective immediately upon all acts necessary to bring it into law. It sounds like everybody, all the stakeholders are on board with that, and it sounds like it will help out the new board with the application period being in March.
Okay, second on that, discussion on that amendment. Yes, go ahead, Representative.
the amendment, if we might also add in section 2, strike after July 1st and put in for 2026 and put in effective date.
Is that a friendly amendment to the amendment?
Yeah, I was just going to ask him
Yeah.
if that was a friendly amendment, because that relates to specifically what applications that it applies to also, so.
So your change would be that would just be when the bill is effective?
Yes.
Okay.
Along with yours.
Yeah,
Okay.
that's very friendly.
Okay. Well,
Or you
Uh,
could put March 1.
I would do that.
Yeah,
I think that's a good.
Yeah,
okay, that's,
okay.
I
Let's
just
go
felt we need to address that.
let's
Great.
do that.
Section
Let's
2.
make
March.
it March 1.
March 1. Okay.
Perfect.
Everybody get that? Ashley, Tanya?
Yeah, one comment, Madam Chairwoman. Sometimes bills are not effective by March 1, so you can't have a retroactive provision in law for
Yeah.
application. So, legally, I think the way to do it is the way presented by Representative Lawley upon the effective date of this act.
Okay.
Any application submitted after that time.
So we'll stick with the friendly amendment to the amendment. then.
Yep, I'll go back to I'll go back to the friendly amendment.
Okay.
Thank you. I'm glad you found it friendly.
Any other discussion on the amendment? Okay, all those in favor of that amendment, please say aye.
Aye.
Any opposed by the same? Okay, that amendment's passed. Any other amendments? Okay, question's been called on the bill. Let's go ahead and take roll. Ashley?
Madam Chairman, for 26 LSO 194, review of charter school applications as amended for sponsorship in the 2026 session. Senator Brennan,
Aye.
Senator Olson,
Aye.
Senator Rothfuss, Senator Scott, Representative Bratton,
Aye.
Representative Erickson,
Aye.
Representative Gudemas,
Aye.
Representative Kelly,
Aye.
Representative Lawley,
Aye.
Representative Singh,
Aye.
Representative Strock,
Aye.
Representative Williams is excused. Co-Chairman Andrew, Co-Chairwoman Schuler. That is 13 aye, 1 excused.
The third member of the trio.
Madam Chair, my name is Leslie Zimmerscheid and I work for the School Foundation Program at WDE.
Okay, welcome.
Madam Chair, thank you. Just to run through this memo real quick and then, of course, be available for questions. We put together some financial information related to the 3 state authorized charter schools that we have in our state now. So Cheyenne, Casper, and Chugwater. We've got their model ADM and their preliminary model ADM for 26. So you can see all of them have grown a little bit in that regard. And the sort of estimated funding associated with each of those state authorized charter schools. And moving into page 3, there are some tables with just somewhat of a breakdown of each of the different components that they're getting through the state funding model. And then more of a breakdown on page 4 down to the different categories. And you can just look through all of those. And then some transportation and special education reimbursement information. And then one thing I did want to bring to your attention that I needed some clarification on is on page 10. And figure 12 has the lease payments for each of the 3 schools. And you'll notice in FY 2025, they were quite a bit more than the first 2 quarters right now, even if you doubled the first half of 2026. And reached out to school facilities to ask why that was. And it's because in the first year, the charter schools do not get O&M payments from us. And then this year, they do get O&M payments in the model, and then the school facilities department reduces their amount commensurate to what we pay. So that's why there's more in their first year than there is this year. With that, Madam Chair, happy to dive in deeper on any of the tables or anything related to this.
Questions? Representative Lawley?
Thank you, Madam Chairman. Vicki, on page, the first page and then over into the second page, I had a little question about the ADMs versus the actual funding. So we see Cheyenne Classical with 150 and funding of 1624,302. And then over under Prairie View, they have 90 students, but their amount is higher. So just explain that. I'm sure there's a good explanation for it, but I'd love to understand it.
Does anybody want to take that one on?
Yeah, I think I'll start, Madam Chair.
Go ahead.
Representative, the per pupil amount isn't the same in every district. The charter schools are tied to the resident district where they are located. And so the per pupil amount in Plat 1 is higher than the per pupil amount in Natrona 1. So that's why they have fewer students, but a larger dollar amount.
Madam Chair and Representative Lawley, I can probably fill that in a little bit too.
Go ahead, ma'am.
One of the things you'll notice is the Cheyenne Classical Academy configuration is different than the Prairie View Community School. And maybe it's not clear from this, but the Prairie View Community School is a K-12 school and the Cheyenne Classical Academy is an elementary school. The funding model under current law allocates minimum teachers on a grade band basis. So in the Prairie View Community School, they're likely receiving a minimum number of teachers in each of those grade bands, whereas the Cheyenne Classical Academy is guaranteed a minimum teacher only for their elementary grade band. So there's a substantial increase in funding or level of funding guaranteed based upon the configuration of the school. So those three grade bands could be generating anywhere from 21 to 24 minimum teachers for that school. So I just wanted to kind of fill in some of that background.
Other questions for the WD? No? Well, I think you guys nailed it. Thank you for all the information. It was very helpful and I appreciate the, because that was a question I had as well as page 10. So you answered the questions before I even asked them. So thank you so much. Anything else you'd like to say about the charter schools at all?
No, thank you.
Okay. Thanks. Thanks for your time. Well, we aren't taking any action on that, but certainly we'll open it up for public comment. Anyone has any comment on it? Mr. Waller, is there anything you'd like to say in regard to this? Oh, okay. Oh, okay, great. Okay, State School Boards Association, anything from you folks? They're hiding back in the corner, so they must not want to be heard from too much. Oh, okay. All right. We're actually supposed to take a break now, but we're way ahead. I did promise I would try to get us at least to stay on schedule.
You're doing great.
I'm doing good, aren't I? Yeah.
You really are.
Well, I would just like to take a minute. Heard this morning that Representative John Eklund passed away. And I just want to take a few minutes to have the folks think about him and his family, keep them in your prayers. I guess his cancer came back, is my understanding. I got to know John a little bit. I didn't get to serve with him as the House members did. I feel bad about that I missed that opportunity, but I found out when I first got to meet him that, again, a guy from Alvin, and I've actually, like I said, been there and spent a week or two there. And my uncle, who was a teacher at the high school, he was the science teacher, taught John. And John really felt like that was one of the best teachers he ever had. And so we always had great conversations, and he did such an amazing job, you know, on the ag committee. I mean, forever, and everything that he did, just a great gentleman. And so I'd open it up if anybody else has any comments. Go ahead.
John was kind of a mentor for me, great encourager in my first term. continued as I got on Select Water to help me along to understand some very complex issues in Wyoming concerning water and the breadth of what we do in the area of water development. Oh, look at you. But he was just a great human, just a good person. His wife Susie as well, a great person. And so it's a real loss to the House, the legislature as a whole, to the state of Wyoming, certainly. But to the House, he had so much kind of what I'd call corporate knowledge about, particularly in the area of agriculture and water, but not just limited to that. But he was also a great encourager. He cared about new legislators, and he was willing to step in if you were open and receive that encouragement, guidance, those kinds of things. So it's a loss, and we need more men and women like him in the legislature. So I just.
Yes, go ahead, Senator.
Thanks, Madam Chairman. John and I came in together. He was a 2011 legislator, and so I've served with him my entire time. I've served in the legislature, and I had nothing but the highest regard for him. He was such an incredibly positive, kind, friendly, supportive person that really thought highly of the Wyoming legislature, the institution, and so he served with class and with honor and certainly with endless hard work. I think he's exactly the type of legislator that we want in either our House or our Senate in the Wyoming legislature, and he'll definitely be missed. He's somebody that, I haven't had the opportunity to serve on committees with him, but he's always one of the first people I look for when the session starts up. John, how you doing? Hear his stories, hear what he's been up to, and it's that positivity that he brought. So he will be missed, and I think he's somebody that people that have had the opportunity to be serving with them, younger legislators, should look to his example and look to his leadership moving forward.
Okay. Oh, go ahead, Representative Kelly.
Thank you, Madam Chair. I didn't know Jen very well. I just know he was a hell of a nice guy. But what struck me was I never told him that. And now I can't. And it makes me sad sometimes we speak so well of people and we never tell them while they're here. So I want to just take a moment to say I'm happy to work with thoughtful, concerned legislators who are truly looking out for your communities. And we obviously don't agree on everything, but we take it in stride and we're respectful of each other. So thank you to all of you in case I'm not here someday or you're not.
Thank you for those comments. Representative C.
Thank you, Madam Chairman. I just wanted to pitch in that that I know that Cheyenne is the big city here in Wyoming, but John was a big member of this community. And even though he represented a more rural part of the state, he touched a lot of lives, not just in the legislature, but in his personal capacity. In the churches around here, we've had the opportunity to just go and visit his little slice of Laramie County and do music in his church community. And just like you guys said before, he was just a man marked by kindness, and every word that he said, you could sense that there was love for, even if he disagreed with you, there was love for the person that he was speaking to. And so there's not a doubt in my mind that he loved this community, he loved this state, and I'm thankful that he was able to serve well.
Thanks, everyone, for those remarks. And like I said, as the good senator mentioned over here, as well as all of you, it's left some big shoes to fill. So we'll be thinking of his family, and be hard to replace over in the House, but sure appreciate everything that he did. So with that, I guess we could, do you guys need a break or?
Never hurts.
Never hurts to have a break. Oh, okay. Let's take just a real quick one. We're ahead of time, but let's take 10 minutes and we'll be back. Welcome back, everybody. We're going to go ahead and continue with our agenda. And just going to mention, there's a possibility that we're staying ahead of schedule a bit. I will try not to get too far ahead, but because we do want to make sure that if there's people that are planning on testifying on any of these bills in the afternoon, that they know we may be just a little bit ahead. But anyway, moving on, we're going to talk about school discipline next. The next bill for our consideration is 26 LSO 0088, K through 12 public school discipline. I could be wrong because, staying ahead sometimes, when you say that we're a little ahead of schedule, and sometimes you get a bill that will we'll just turn the tables on that. But anyway, hopefully we can get all the information we need with our LSO, Tanya and Ashley.
Madam Chair, members of the committee, I'm here to present 26 LSO 0088. Just a little background on this. The drafting instructions initially were provided by Chairman Andrew for this particular draft. And then recall you had two bills at your last meeting in August that sort of addressed the same subject, and many of the provisions were duplicative. That was 0091 K-12 Public School Bill of Rights. And at the last meeting, LSO was instructed to take the Department of Education's proposed amendments, make those, and then correspond with Mr. Jones about his concerns. And so those changes have been made to this particular bill draft. And I will go ahead and walk the bill. And generally, this bill modifies existing law or provides clarification regarding student discipline and school district's obligation. And it would note at the outset, because I will forget this, the two provisions are repealed in this act. It's they're noted in the back, and the substance is there as well. So I just wanted to mention that at the outfront so that I didn't forget it. Beginning on section 1, page 2, lines 1 through page 3, this amends 214308. This is the disciplinary measures. I think it used to say punishment, but the title of the statute has been changed. Generally, this requires school districts to adopt rules or policy for the students' discipline. It provides school district employees with authority to enforce those rules and policies. And it also includes that those policies are effective on any school district property, including, and property is defined there, school district property. So it's basically any school building, obviously, but sometimes they play sports at a different location or they're on a field trip. And so those are also included in that definition. Paragraph 2 on page 3, line 11 allows school district employees to enforce those rules and policies that are created under subsection A. I would note, if you take a look at the intro provision of paragraph 2 and paragraph 1, much of that language is duplicative. I do think there's a way to consolidate those. I do not have an amendment prepared, but that's the consideration and a policy decision for this body. But I do think it confuses and perhaps confuses enforcement of the law, because you have these two provisions that are very similar and districts are trying to figure out, like, they're obviously two provisions. How are they different? Moving on to page 4 and 5, subsection or subparagraph B. Now, this provides for the enforcement mechanisms. There are several listed there, including removal of the student from the classroom, referral to the higher ups, the state superintendent of the school district, board of trustees, and the principal. It also requires notice to teachers that the teacher that removed the student This provision requires notice to that individual, and it also requires that the school district consult with that person. And in the event that the proposed consequences deviate from her or his recommendation, she's required to know that she or he. Page 6, line 1 creates subsection D and D. And as I noted, the reason it's D is because B and C are repealed. So you have A and then D. These are the consequences that can be imposed by the school principal, the school district superintendent, or the board of trustees. These are definitely more aggressive punishments. So in-school suspension, dropout prevention, and academic intervention, exclusion from participation and attendance of school or district-sponsored events, activities, including extra and co-curricular. And then, of course, on page 7, suspension and expulsion in accordance with 21-4, 305, and 306. And those are the provisions that provide due process for the suspension of students. Moving on to page 7, line 4, subsection E provides the teacher the ability to request assistance from school district personnel in enforcing the rules and policies and perhaps the removal of the child. Subsection F on page 7 requires professional development for teachers to ensure that they have high quality, that students have a high quality, adequate education in kindergarten through grade 12. Subsection G on the bottom of page 7 requires a minimum of 1 planning period for teachers each day. Moving on to page 8, subsection 8, line 4. This requires school district personnel to report any potential violent crime to the superintendent and the principal. And it also provides that the school district will defend that individual and support the actions of that individual so long as those are made in good faith. Subsection J, page 8, school district board of trustees are required to take reasonable steps to ensure the physical safety of students in the event that physical violence is likely to occur on school district property. Subsection K, page 8 onto page 9. This is the provision that requires that the individual is not subject to professional disciplinary proceedings for taking actions such as reprimand or negative employment actions. The one thing I would note here is the state board has basically been eliminated from this bill draft, but in the drafting instructions, there was a single reference left. If you look at page 8, line 21 onto page 9, line 1, that is maybe a technical correction, but something for the committee to consider. And then subsection M, beginning on page 9, line 14, these are reporting requirements. The school district is required to, the schools are required to report to the school district, and then the school districts are required to provide that information to the Department of Education. And then on page 10, the Department of Education is required to provide those reports to this committee. There's a comment to a staff memo overview of school discipline, suspension, expulsion, seclusion, restraint. That highlighted or underlined blue language, if you click on it, you can read it. We presented it at a prior meeting, but I thought it was important for just to remind people of what that process looks like currently. And then as I mentioned, page 10, section 2, this repeals subsections B and C. And if you look at the bottom of page 10 and onto page 11, you can see that language. Basically, subsection B, there's a lot of discussion at the last meeting, but it eliminates the immunity from civil and criminal liability in the exercise of reasonable corporal punishment. And then C is the provision that you can't have a diploma in the event that you have fees. And so it's prohibited in that provision, and this repeal will eliminate that. Subsection 3 on page 11, lines 13 through 16. This is the drop dead date for school districts to comply with this act. And that is August 1st of 2026. August 1st of 2026. And that's a policy decision for you all. If, the school districts, there's no magic about that date. If the school districts require more time, you could certainly extend it. And then lastly, this act is effective immediately. In part, that's on page 12, lines 1 through 4, in part because of the date that was previously mentioned, the August 1st of 2026. So subject to your questions, Madam Chairwoman and members of the committee.
Questions for Ms. Heitrick? Yes, go ahead, Representative.
Thank you, Madam Chairman. Tanya, first of all, I just want to confirm something that I know has been a subject to some confusion. That's not really in the bill, but about the bill itself, which is that this bill does not cover in any way affect the federal requirements under IDEA, Section 54, the special ed requirements as far as the issues of suspension, expulsion, all these things, that those are covered by the federal law. Is that a fair statement?
Madam Chairwoman, Representative Lawley, great point. And I should have maybe mentioned that, but federal law in all instances is the ultimate law, and then state law is subject to that. And under IDEA and Section 504, there are specific provisions that govern discipline of those students. There's due process involved. It's a much different standard than this. And so you could put a provision in here, but by operation of law, your statement is accurate.
Follow up.
Yes, go ahead, follow up.
Thank you for that. I think it just has been a little bit confusing. We were, I think, operating all in that understanding, but some in my district raised that, and I think it was good to kind of have that clarified here at the beginning as we work through the bill. And I just want to go then to page 3, if I might, Madam Chairman. And I agree with you that this looks like really duplicative language. I tried to see if there was anything in the second part that much added here. But do you have any thoughts? Because do we just delete, you think, that double Romanet 2 there on line 11 on page 3, and then maybe add something like including, since we then have this list of things, I'm just thinking, how would you recommend consolidating that and kind of making it a little more crisp and clear?
Ms. Heitrick?
If I could have just a moment. I do think they can be consolidated, particularly Romanet 1 on page 2, lines 18 through page 3, line 3. And it does seem a bit out of place to have the definition of the school district property in that particular provision as well. And so my suggestion would be to combine lines 18 on page 2 through page 3, line 3, into Romanet 2, and which will now become Romanet 1. And then perhaps for purposes of this section, you include that in subsection A on page 2, line 8. Or create just a separate Romanet there that identifies that for purposes of this, all school districts shall. That might be the better way to do it. On the fly, that would be my recommendation. And you could certainly direct staff to conceptually do that. That's not my favorite at a final meeting to have a conceptual amendment. But I could certainly do that. This seems fairly straightforward. It's an organizational issue, it would be non-substantive. So I would feel comfortable with that if that were the direction of the committee.
Thank you. That was very helpful. One more.
Yes, go ahead. Follow up.
Thank you. Thank you, Madam Chairman. Tanya, on page 7 and lines 19 and 20, and then over onto page 8, 1 and 2. Well, I don't necessarily disagree with this as an idea, and certainly to give some teachers some relief. I'm not sure I understand the nexus between this provision and discipline in particular. What's the nexus? Like I said, I don't necessarily disagree with this. Might be a good idea if it was able to be accomplished, but is there, can you help me with that?
Go ahead, Tanya.
Certainly, Madam Chair and Representative Lally, I don't disagree. I do think this is sort of out of place. And if you recall, one, that wasn't a decision made by LSO. That was the recommendation from, I believe, the Department of Education and their amendments trying to consolidate 91 with this bill. And when you look at 91, that was a teacher rights bill, but it also included a lot of disciplinary measures. And I don't disagree. Those are two sort of separate concepts, the teacher right versus discipline, even though there was a lot of overlap between those. I don't know if it's, you can leave it in here, just knowing that it's kind of out of place organizationally. Being type A person, obviously that's annoying to me, but certainly you could do that. It's not the only place where we've included sort of a one-off in a statute, but that's a policy decision for you all.
It's interesting that co-chair and I both had that question marked as well. And I think you're exactly right. I think districts already generally take care of that, the planning period issues, but to have it included in this bill, I don't think it hurts it. I don't think it helps it. I think it's, kind of harmless either way. So thanks for that. Other questions from the committee? Senator Scott.
Madam Chairman,
Go ahead, Tanya.
No wonder you couldn't hear me. My mic wasn't on. Page 3, lines 3 through 9. And at the very bottom, it says, regardless of location and transportation to or from school-sponsored activities. And you could add a provision there that says, including transportation. I think this is broad enough to include that, but if you really wanted to nail it down, I can come up with some language that, includes transportation to and from school for educational purposes or something like that. Because certainly I see your point. School district sponsored activities may not cover to and from in the regular bus route. And then secondly, to your second question, I would refer you to page 3, line 13, which provides all school district employees the ability to take actions for the safety of students, and that was intentional. There was a lot of discussion in the last meeting about teachers versus school district personnel. And I had those discussions with Chairman Andrew in creating this bill draft. So all school district employees, custodial, bus drivers, paras, teachers.
Follow up, Senator Scott?
Yeah, and in that particular provision, what I've seen a number of school district employees do is directly call if they get kids acting up, right? They call the kids. Because it can be very effective, but you will get the odd parent, Madam.
Tanya, go ahead.
Madam Chair, Senator Scott, it certainly is covered. School districts have the ability and the latitude to create policies and rules for classroom management and enforcement. And should a school district choose to include that as an option, that's certainly available to them. There are several mechanisms listed specifically with regard to that, but certainly a school district has a latitude in their rules and regulations to adopt that provision as a first step, call the parent or whatever it might be.
Follow up, go ahead.
In the absence of a policy, does the school employee that takes that step have any protection?
Go ahead, Tanya.
Yeah, Madam Chair, Senator Scott, again, school districts have the latitude to adopt policies, and they're actually mandated by this bill. So there's no ability not to adopt policies. And one point I'd like to go back to about the school buses, and thankfully, Ms. Phillips helped me out here, but page 3, lines 4 and 5 provide any property owned or leased by the school district. Buses are property of the school district.
Further questions? Certainly, go ahead, Representative.
A broader sort of issue, maybe / concern I have is clarification of the parent's role in this process. Can you direct me if the bill really it does that? Obviously we have the parental rights and education law now, and it directs certain notices and things. But how do parents looking at something like this say, where do we get involved? Where are we entitled to get notice? At the beginning of the process? So we are aware there's a problem with our child. So I'm kind of trying to, even myself, understand the interplay between the Parental Rights Acts we already have with this, and whether or not in this space we need to make some reference to at least notice to parents concerning the process or different stages of the process. So
Go ahead, Tanya.
I just wanted to be sure on this answer, Madam Chair, Representative Lawley. I think your point is well taken. There's no specific provision in this bill draft that includes the parents, but I would note the parental rights bill still is effective, and you do have to read the law together. And certainly under that particular law, you would be required to notify the parents of any discipline of their child.
okay,
If you wanted to, yeah.
follow up.
Go ahead.
Okay. And you can continue, and then you may answer my question.
Madam Chair, Representative Lawley, I was just going to say, if you wanted to nail it down affirmatively, you could certainly add a provision that says, you know, in the event that the school takes any disciplinary action of the parent, they shall be notified, you know, in a reasonable time or whatever. And if memory serves me right, which is always dicey, I think 91 had a provision for parental notification, and I can go back and look, but that's my recollection.
Okay, follow up.
Yes, go ahead, follow up.
Yeah, I do believe there's a number of notification provisions there in the Parental Rights Act. We have, what I'm not really sure of, and I will have to look it up, but whether or not it included specifically disciplinary action. I kind of think we might have a gap there. And so I think if we do, while we're here, we might want to clarify that on notification. There's a little bit of another issue and unless we would assume once they're notified, they are invited into the process, so to speak. So I think that's a slightly different issue of notice versus when they kind of have the right to intervene or be a part of discussions or meetings. And I don't even know that that's a problem. I'm not suggesting that, but I think we do need to kind of deal with that. I think with this bill, it's been brought up to me by parents about that. When do we get notified? So I think we want to be more specific. I'm not sure, again, I haven't looked it up yet, but whether or not the statute we have now specifically gives a notice about disciplinary action, but it might, but I don't believe so, but.
Tanya, do you want to go ahead and comment on that?
Sure, Madam Chair, Representative Lawley, 2 points. One, I can certainly look at that issue. It's not one that was brought to my attention previously, but I will look at the Parental Rights Act to see if there's a gap. And I can come up with some language conceptually on that. And I forget my second point. So, this is a policy decision for you all.
Other questions? Yes, Representative Brown.
Thank you, Madam Chairwoman. I do remember that there was discussion, it might have been in August on 91 that we had, and I can't remember if we amended it but it was about this parental notification, perhaps by the end of the day. I think that's what it was, but I remember that also. So thank you for bringing that up.
Other questions? Yes, Senator Rothfuss.
Thank you, Madam Chairman. My questions goes back to the earlier discussion about this applying to school district employees and providing that authority to school district employees. It doesn't seem like the way the shalls are written, there's a lot of discretion for the local board of trustees to provide different levels of authority to different classes of employees. It seems like every district employee shall have a right to remove by reasonable force any student from the grounds of the school if they believe that student is acting against the educational interests of other students. For example, like as I read it through, I'm pretty sure the custodian could take my son and remove him without asking or consulting anyone else from his middle school and use reasonable force to do that as written. Am I tracking that correctly?
Tanya, go ahead.
Madam Chair, Senator Rothfuss, yes, that is true. This is a broader application, and there are, as you stated, the policies are required to include enforcement of classroom management, reasonable force. Certainly, as written, in my opinion, the custodian could remove the child. In 91, there were different provisions. There was a distinction between school district employees and teachers. I think it went so far as to say teachers where the student was enrolled or participating, something like that. that teacher could remove them. And so there was significant discussion by the committee at the last meeting about who this applies to.
Right.
And, you know, I don't have an opinion on that.
Yeah.
Your
Just making sure I'm
interpretation.
reading it correctly.
Yeah,
Exactly.
it's correct.
Okay, and Madam Chairman, just to clarify that, the school district would not be allowed, for example, to write a policy that said, no, that custodian would have to take that student to the principal's office and the principal would have to make the decision. I think it's precluded from having a policy like that. Am I understanding that correctly?
Tanya, while you're looking
Yeah.
at that, I would just, to follow up on Senator Rothfuss, I've looked at this too. I have some of the same concerns, but in a way, on page 4, when we talk about reasonable force may be used by a school district employee to remove a student from school district property, to prevent injury of the students or others. I think that kind of gives us the out that we need, because, and I will say this as a high school teacher, most of the fights that I saw, you know, sometimes lunchroom, sometimes, you know, outside. Quite often there was a custodian around, and it was great to have them around because sometimes they were bigger and tougher than I certainly was to stop a fight. So I see where that, I mean, could cause some consternation, but I think also it may be used if it's to prevent injury, because kids nowadays, you know, they can pack a punch, some of them. And so I understand completely, Senator Rothfuss, but to get back to your question, I
Certainly.
just throwing that in there.
Apologize for the delay. Just wanted to be sure. Madam Chair and Senator Rothfuss, I think you're correct. The policies required under this act currently are very prescriptive and do apply to all school district employees. And I don't believe it's a may in this bill draft. I think it's you shall have these
That's what I thought.
elements in your policy. And certainly within each one of those, you could, you know, you have some latitude, but you are required to have a policy where any school district employee can remove a child by reasonable force. But that's a great point, Madam Chair, that it is limited to the instance of, you know, in the event that it's going to ensure the safety of students and the school district employee. So to prevent injury of the student or others.
Well, Madam Chairman, it includes the clause, maintain the opportunity for all students to learn as a series of oars, such that that is in and of itself sufficient. So there doesn't have to be any violence. There doesn't have to be any threat of injury. There doesn't have to be any risk. It is simply at the discretion and judgment of an individual, the ability as to whether or not a student is sufficiently problematic as to basically reduce the potential for other students to learn, which I don't mean to make light of. That's annoying, but not necessarily rising to the level where the custodian or bus driver or groundskeeper should be using their judgment to remove a student from the grounds of, again, not taking that student to the principal, literally potentially removing them with absolute indemnification from the grounds of the school, which is honestly in and of itself also scary in a Wyoming winter under any circumstance. So I just wanted to make sure that I understood that. One other question, it's the language about a student not returning to classroom until written permission is given by that teacher. That was a discussion that we had before, and it sounds like there with the shalls, there's no exception to that. I guess I have the concern about due process there and an allowance for a student to work with the administrator of the school, their parents, and some type of due process situation to get back into the classroom without it just being unilaterally a decision of the teacher, where the teacher has veto authority. Am I reading those shalls correctly, that it would be a unilateral veto of the teacher.
Ms. Sitrack?
Madam Chair, Senator Ruffus, in response to your first question, you are correct. There are basically 3 clauses at the bottom of page 4. 1 is to prevent injury of students or others. 2 is to maintain the opportunity for all students to learn, or to ensure the students of the safety, the safety of the students and school district employees. All 3 of those are applicable and would be a viable option for an employee to remove a student. And then with your second point, there are due process concerns, certainly with suspension and expulsion. If you're denying the student an opportunity to learn for, days on end, and as stated in the bill, there are specific parameters and administrative procedures surrounding that. And those are outlined in the memo.
Yeah.
And it's 21-4-305 and 21-4-306. There's case law that indicates that school districts have the authority to maintain a learning environment and can take reasonable actions to do that, and that is not a denial of your educational right. If you have the opportunity, that's how they phrase it, you have the opportunity to learn. And in the event you choose to be violent or disruptive, the school district can take actions for the other students to have the opportunity to learn. There's not a bright line on that. I think there are 2 cases that cover it. And so that would be the response to that. Certainly, if you want to involve parents, that's a policy decision for you all.
Thank you, Madam Chairman. I was kind of specifically looking at page 6, Romanet 1, line 8, which gets to no student removed from a class shall be placed in the class from which the student was removed without the written consent of the classroom teacher. And again, it seems like that's a string of shall clauses where that's an absolute. So if it seems to me that if that teacher does not provide written consent, that there's no other course of action as written for that student to return to classroom.
Ms. Sitrack?
Madam Chair, Senator Rothfuss, I think that is the correct reading of that particular provision. I was looking for another section where it discusses in the event that they deviate from that recommendation. Just give me one moment. Madam Chair, Senator Rothfuss, perhaps I'm thinking of the alternative bill.
I think what you're thinking might be page 5, line 15. I was just trying to go back and find it, and I think that might be what you're referring to. They're sort of in conflict, actually. Because I think there's an implication in that sentence beginning on line 10 that the district can do something other than what the removing employee wants, but then below it seems to indicate that they can't.
Madam Chair, Senator Rothfuss, I agree. And that is the language that I was looking for, so I appreciate your assistance. And again, LSO didn't draft.
Yeah.
These are not policy decisions that LSO made. These are policy decisions really that the Department of Education provided you.
Yep.
And sort of pushing these bills together.
Great, thank you. I'm done.
Representative Bratton, had a comment or a question?
Yes, thank you, Madam Chairwoman. Would online learning, if a student is removed from the classroom, the teacher does not want to give written permission for that student to come back, then wouldn't online learning still provide the opportunity for that student to learn?
Madam Chair, Representative Bratton, I do think that those students are enrolled in a public school, and so there could be specific policies about removing them. But yes, you have to maintain the opportunity to learn for a student. That's a constitutional obligation. And so in the event that you were removed from an online course for disruptive behavior, you would need to provide an alternative class for that individual through those provisions, outlining the various consequences.
Follow up?
Yes, I just meant if they were removed from the classroom, then there would be the opportunity for them to learn, to take advantage of online learning as an alternative to going back to the class.
Yeah, Madam Chair, Representative Bratton, I apologize for answering the question that you didn't ask. But yes, that would be an option, that they would return to a classroom, and it could be distance learning as an option.
All right, thank you.
So,
Other questions? Yeah, Representative Lawley?
Thank you. As long as we're kind of continuing on this line, I guess I read this provision as a protection for a teacher who has had encounters or several encounters with a student. And as a result of that, feels like those situations aren't resolved and there's a lack of safety for her or him in the class. And so the idea is they can't go back into that particular classroom because of that. I mean, I think that's what it's written for, really to protect teachers and I think more extreme situations that may involve some threat, either violence or threats of violence. But that's the way I read this, is it so you can't force them back into that class, but maybe there's another grade level class they can try over there with some, encouragement of the student towards different behavior. And I think there are still alternatives for the district that are normally just exist in managing different situations within a district. But that's the way I read this, is that has more to do with that specific classroom, not necessarily returning to the classroom environment, but is more related to the environment class of that teacher. But is that a fair reading?
Madam Chair, Representative Lawley, yes. I mean, when you look at page 6, lines 5 and 6, it states if a student is removed from a classroom, placement in an alternative classroom is an option. So, I mean, you must ensure the opportunity for a student to learn, but you can't deny other students the ability to learn because of disruptive behavior. And I would say it's lesser than sort of the violent student or the repeated, instances. It says the opportunity to learn if it interferes with the opportunity to learn. And thinking, if I might, thinking a little bit more about Representative Bratton's question, if you wanted to specifically include online learning, we could do that in the definition of school district property, because that is written more to address physical buildings or a bus or something like that. And so you could add just a provision that references online learning if that's a concern.
Other questions from the committee? Okay, seeing none. Guess you guys are off the hot seat, at least for a minute. All right, we will go ahead and State Department of Education, do you want to start the ball rolling with public testimony? Love to hear from you.
Thank you, Madam Chair, Committee. Nathan Tujeski, Wyoming Department of Education. I just want to thank you for your work looking at this bill. The superintendent, through her teacher retention and recruitment task force, as well as just conversations with teachers throughout the state. School or classroom behaviors is one of the top concerns of teachers, right below compensation. So your attention to this is really appreciated. And if you have any questions on the bill, we'd be happy to answer them.
Questions for Mr. Tujeski? Yes, Mr. Kelly, or Representative Kelly.
Thank you, Madam Chair. It's Senator this morning, according to a news outlet. Section M about reporting. Can you please expand on what the Department of Education does with these reports?
We'll let either one of you take that on.
Madam Chair, through you, Representative Kelly, and you're referring to page 9, MI, and the Romanet 1, Roman 1, 2, and 3. So when the department gets the report from the district and then reports to this committee, that is something that there is a data collection on discipline, but this would be a different data collection. So we aren't really actively doing anything with this right now, but we would, if this were to pass, collect it, organize it, prepare a report for this committee.
Thank you, Madam
Follow
Chair.
up? Yes, go ahead.
Yes. It reports to this committee, which is temporary changing membership, meets a few days out of the year. Could you maybe evaluate how useful you see these reports in doing anything effective to promote school discipline?
Mr. Shaner?
Madam Chair, through you, Representative Kelly, I think it's always helpful for us to have a statewide sort of landscape understanding of these types of issues, and it's something that we haven't really had a good grasp on up to this point. So the more information we have, the more capable we are of trying to address any issues.
Other questions from the committee? Yes, let me start with Senator Olson, then I'll come back to you. Senator Olson?
Thank you, Madam Chairman. So yeah, I was interested in this same section. Originally, I was going to ask if there was any reporting because it seems like that's a pretty big ask to ask every school to report all disciplinary actions. So, but it doesn't sound like we're doing that, so we don't know exactly how big of a task that would be. But my second question would be the data itself. I would like to think is de-identified, and that will be put in place by your rule. Because this statute doesn't specify how the data is reported to the school district or how it's reported from the school district to the department. And I'm just concerned about what type of data is being shared and the privacy of the students.
Mr. Shaner?
Thank you, Madam Chair, through you, Senator Olson. And that's something actually Mr. Tedeschi and I discussed this morning, was that there might need to be some limiting factor when it says all student disciplinary actions, about maybe major disciplinary actions or something. So it's not every time a kid is sent in a timeout or whatever. There is a federal, currently we do a WDE 636 disciplinary actions and crimes and violence. We have a guidebook and there's some data reporting. So imagine that we would try to do our best to, whatever's needed out of this legislation, map that to the existing data report that we have. And yes, of course, always FERPA and student data privacy is top of mind with any of these collections and any sort of public sharing of that information.
Any other questions? Okay, Senator Rothfuss.
Thank you. I'm going to follow up on Senator Olson's real quickly. FERPA doesn't guarantee that it's de-identified. It just provides for a set of rules for restriction on who can be shared with, and sharing between the department and the state is probably going to be 100% protected in any capacity for FERPA. I can't imagine anything where FERPA says you can't share that. We did work on statutes a number of years ago that tried to limit the data sharing of unnecessary data and make sure that it's de-identified where available. But this statute doesn't call for that. I think there probably would be interest if this legislation went into effect to ensure that it's de-identified. Would there be any problem with that, adding that this is de-identified? I can't, and I don't think your federal, I think we had this conversation before, and I'm recalling that your federally required report does not require an identity associated with your report. Is that accurate?
Mr. Shaner?
Madam Chair, through you, Senator Rothfuss, yes, that's accurate, and no issue with de-identifying in this bill.
Okay. And Madam Chairman, on a separate line of questions, you know, as I looked through this draft of the legislation, I guess I'm a little concerned that we're going with the mantra that one of my former Senate colleagues would frequently say, which is if something's worth reacting to, it's worth overreacting to. And we may have done that here in my mind. So I just wanted to hear from WDE. Are you comfortable that this doesn't go maybe a little bit too far in being overly prescriptive and overly generalized in the protection side? And I think we all agree on the need for this purpose. So I'm not questioning the purpose of the bill, but more what this would actually then do on the ground, so to speak. Has that really been thought through and worked through? And is this the appropriate level of indemnification for actions and guidance for school districts? Or should we really be, taking a harder look at this and trying to find some middle ground?
Thank you.
Mr. Shaner?
Madam Chair, through you, Senator Rothfuss, I think some of the discussion this morning, whether there's a may or a shall, who is, designated by the principal and has what authority, if there's a need to be more clear in that statute, we certainly think that's appropriate in terms of the political realities, whether that's done today or in standing committee during the session. Couldn't really speak to that, but I think that there's room to make it more clear so that everybody understands exactly what who has what authority. But in reading it, really a lot of discretion is still given to what is in those rules and policies adopted by those school districts on how this all plays out. And I think at the core of it, the enforcement authority, the things laid out will be dictated a lot by what the district puts in their policies or rules.
Madam Chairman, following up on that. And I mean, that's my concern is I don't think it really does give a lot of discretion at this point in time to the school districts. And I think that's probably what's lacking. So that does seem like something in general that you and the superintendent would support, ensuring that districts have the capacity to try and get this to the right place and do the right thing in a sensitive way where the role of the employee makes a difference and that they have the capacity to put in place appropriate workflows as necessary. Is that fair?
Mr. Shaner?
And Madam Chair, Senator Rothfuss, I think it is, but I think there's an argument that exists to a degree in here too. But certainly, if the degree needs to be enhanced, I think the superintendent is certainly open to that.
Madam Chairman, final. There's a tension obviously in a bill like this, and you've got parental rights and parental interests and independence on one side, and then you've got teacher and school districts, and those are coming into tension on this. And I was wondering if this draft had been vetted by the parents groups that the superintendent has been working with, and whether they're comfortable with this approach to discipline by the schools. I think to me, it seems like the pendulum might be swinging a little far. When I put my parent hat on, I'm a little worried about this bill. And so I was wondering if the superintendent or any of the policy staff had worked with those parent groups on this legislation.
Mr. Shaner?
Thank you, Madam Chair. Through you, Senator Rothfuss. I'm not aware of her working on this specific draft with a parent group.
Okay.
I know that we've had our special ed advisory group, which is parents, but it's with a special ed lens, have looked through both drafts from last time. So it's previous to the consolidated version, and gave some feedback to the question that Representative Lawley raised about the overlap between the two. But I don't know about specific on this draft.
Madam Chairman, I said last point, but that raised a separate one, so my apologies. On the special education, there's no question, as Representative Lawley pointed out, that federal law is going to trump whatever we do in this legislation. So where there's a conflict, IDEA and other federal law are going to govern. But My question would be, how would the district employees know? How would the groundskeeper know? Oh, I'm sorry, Timmy's under IDEA and has an IEP back in the principal's office. So I need to go double check that I'm not bound by state law. I need to figure out what the federal law actually says for how I can restrain this individual child when I'm escorting them from the ground. I don't see how it plays out in reality, even though, yes, I absolutely agree that federal law trumps this. But with an inelegance of subtlety through the legislative draft, I don't know how on the ground when it plays out, anybody has any idea whether the child is governed by IDEA or state law. Any thoughts on that?
Yeah, that's a good question.
Mr. Shaner.
Madam Chair, through you. An IEP being covered by IDEA does not exempt you from school policies. It doesn't exempt you from school discipline. So an individual who'd be, sorry, I'll get closer. It's green. An individual who would be interjecting in a situation, they're going to deal with the situation first and deal with the consequences second. So in a safety matter, for example, if there is a student who is having a violent outburst in a classroom, an IEP doesn't exempt them from the school district's rules and policies because they have that IEP. The follow-up to that situation, yes, the IEP is going to take an effect there, but the situation needs to be dealt with first. Now, caveat to that, there may be special parameters with a given student that, hey, MANT training is a great example. When we talk about any sort of restraint or physical intervention, people are trained to deal with those situations with those specific students. So when we talk about the janitor or the groundskeeper being the person to intervene, the majority of the time, the vast majority of the time, those students have some sort of paraeducator or special education teacher associated with them. That's who would be called. It wouldn't be the custodian to come deal with the situation.
You sure, Senator Rothfuss?
I'll stop there.
Okay. Other questions from the committee? Okay, thank you so much. All right, let's go ahead and open it up for more public testimony. Anyone in the room that would like to testify on this bill, please come forward and introduce yourself. Welcome.
Good morning. Thank you, Senator Schuler, Representative Andrew. I know you guys are co-chairs, so I appreciate you guys hosting this for us and allowing us to speak today. I'm honored to speak before all of you on this today. My name is Patricia McCoy, and I am here as a citizen of Laramie County and also on behalf of the parents in Moms for Liberty of Laramie County to speak on this bill. I want to acknowledge first the positive aspects of this bill. There are positive things in this bill. We strongly support provisions that reinforce teacher authority in the classroom and prevent disruptive students from returning without teacher consent. More often than not, we see that a teacher will send a student to the principal will hand them a candy, tell them that's not good, you need to be nice to your friends, and send them right back to the classroom to the same teacher where the behavior continues and propagates. It's essential for maintaining a safe and productive learning environment that the teachers feel that they can send them to the principal and they won't be sent right back. We also appreciate the removal of diploma withholding for unpaid fines, which ensures that academic achievement is not penalized for financial hardships. Being a citizen on the south side of Cheyenne, I can tell you that affects several of our students. So thank you for taking that out. They don't have to stress about that anymore. However, now that I've done all the good feel-good stuff, it's time for the bad news. There are some serious concerns with this. Representative Lawley brought up a good point when it comes to parental oversight. Parents are the primary stakeholders in their child's education, and any disciplinary action beyond routine classroom management, sit down, don't do that type of thing. If they're being suspended, if use of force is something that must happen, it must also include immediate parental notification and an opportunity for appeal. Why do I say opportunity for appeal? Sometimes, as been discussed already, a child just doesn't mesh with that teacher, and that teacher just doesn't mesh with that child. I've had it happen to some of my children, right? They just don't fit in that classroom. But that classroom down the hall, if they get along with that teacher, great. They're going to soar in that classroom. There's also broad authority risks, which Senator Rothfuss brought. Thank you for that, Senator Rothfuss. The current language granting all school employees authority to punish students, I don't like that word either. I'll discuss that later. It's very troubling as a parent. Like Senator said, anyone could now take this authority. If a custodian sees a student acting out in the lunchroom, they now have the authority to handle that, whether by force, just saying, hey, let's go see the principal, whatever that may be. But if that custodian puts hands on my child, I can tell you right now, we're going to have a different conversation, especially if the situation wasn't where my child was the instigator. How often do we see a fight break out? Both children go to the principal's office. We're trying to figure out who was the instigator, who isn't. We can't figure that out. Both students are now being punished. That parent should have a right to advocate for their child to not be removed from the school if they were not, in fact, the instigator, and to fully investigate the situation. And I don't see that in the bill as it is written right now. We also need transparency and local control. Discipline policy should reflect community standards, not just state mandates. So we recommend requiring districts to publish their discipline policies and provide annual public reports on disciplinary actions, because this will promote accountability and trust. Right now, as a parent, if I went to my school district, Laramie County School District 1, and I said, I want to report on how many instances where a student had to be removed for bringing a weapon to school, I would be told I can't get that information because of student privacy. We had an incident at our school that was a hate crime, classified as a hate crime. Parents went to the school board, several, wanting to know what happened, what's being done to handle this situation. There were serious concerns, and every single parent was told, sorry, we can't give you any information. We're not going to tell you how it was resolved because that violates the privacy of a student. You can provide that information without providing the student information, such as Senator Rothfuss had stated previously. We can have reports that show there were 10 instances of students bringing a knife to school. There were 20 instances of a student throwing a chair in the classroom, which has happened to my student. He's been hit by chairs in elementary school in the classroom. It happens. But where's the accountability? Where's the transparency so that we know exactly how many instances is this happening? Is this a large issue? Is it a small issue? Without that information, nobody knows. And I think it's great that they want to bring reports to you guys. I think you guys need that information, but I think the district as a whole and the community also needs to have that information. And then as Senator Rothfuss, sorry, I keep pointing you out today, sir, but I actually agree with you quite often today. Student rights and safety. The student has a right to due process in any situation where they are in trouble, whether it's throwing a book, throwing a chair, cussing out a teacher. I don't care what the problem is. They still have the right to due process for that. And reasonable force sounds great. What does it actually mean? Does that mean that the custodian today feels like tackling Johnny to the ground is the best way to use reasonable force? Or could he have just wrapped his arms around him and sat him down and held him instead of tackling him to the ground? What does that actually look like to a student, a parent, and a teacher, or a school custodian? I also know that you guys have been discussing why this is needed, what it's not needed. The school districts already have this authority. I just want you to know they could do it. They already have disciplinary policies in place. LCSD1 has one. They have executive sessions to discuss suspensions and expulsions after almost every board meeting. So why do we need this other than transparency and accountability? We need the reporting on this to back up what everyone is saying. We know there's kids out of control, but why is that? Why are they not using the authority that they already have been given? Is it possibly because federal compliance concerns, especially involving IEPs, it creates hesitation when those IEPs are in place, right? What can I or can I not do in that situation? There's also administrative decisions where they prioritize keeping the student in the classroom over the teacher's recommendations and safety requests. Like I said earlier, you have a teacher send Johnny down to the principal's office because Johnny threw a chair at Susie. Principal tells Johnny, that's not very nice of you. You need to be nice to all of your friends. Here's a candy. Let's calm it down, and sends them right back. It's just a vicious loop. It doesn't solve Johnny's behavior problems. It doesn't help the teacher keep them safe, but the administration will keep sending them back. Where's the accountability when the administration does that? How often does a principal or a district employee override that teacher's recommendation? We don't know. We don't have any way to track that right now. It also, if the district ignores teacher requests for removal, overrides recommended consequences, and returns disruptive students immediately back to class, or fails to follow on its own policies, nothing in this bill does anything. There's no teeth in this bill to hold them accountable. There's no punishment for the district. You have punish listed in this bill when you're talking about students, but there's no punish listed for the districts that don't follow through. They have the authority now, they don't follow through now. What in this bill is going to make them follow through with that? And with that, I will stand for questions.
Questions for Ms. McCoy, Representative Kelly.
Thank you, Madam Chair. I'm glad you brought up that last point, kind of what I was getting to with what do we do with these reports? Are you saying then it would be more effective to have these actually bring about some transparency, that districts would be required to put these on their websites, so the Department of Education would make this public data? You could compare districts among districts, see how many kids are getting expelled, how often there are violent incidents in schools. Is that what you're saying?
Ms. McCoy?
Co-Chair Schuler, thank you through you. Representative Kelly, yes, that is exactly what I am saying. It is much needed. And I appreciate you bringing that up to the Department of Education, because as he stated, they make reports and send them to you. You guys meet every few months, is that correct? A few times a year? What happens in between? Where's the accountability for parents to keep their kids safe, the teachers to keep themselves safe in between your meetings? Who's watching over that? Who is the Department of Education? No offense to them, they're fabulous. They should be overseeing this. If the districts are not following through, if principals and supervisors in the district are overriding teachers and sending kids back to class, parents and community members have every right to know that.
Follow up? Go ahead.
I have a separate question. Is that okay, Madam Chair? Thank you. Page 4, line 11. I have an issue with this. I want to get your thoughts on it. Removal of disobedient, disrespectful, violent, abusive, uncontrollable, or disruptive students. Having been a teacher, having been a special education teacher, being alternatively wired myself, I have issues with the physical removal of a disrespectful or disobedient child, as those are so subjective terms, as I am used to students walking to class saying, "What's up, Tom?" And I'm okay with that. But other teachers may find that disrespectful or disobedient because they were told not to do that the day before. So what are your thoughts on this idea of using force for such a subjective term like being disrespectful?
Ms. McCoy?
Thank you, Co-Chair Schuler, through you. Representative Kelly, thank you for that question. I've actually had situations where I would agree with you. It is very vague. It is very subjective. My child had a teacher that, like you, would, "Hey, what's up? It's cool. You could talk to me however you want." And then there were other teachers that they had where you had to say, "Yes, sir, yes, ma'am," and you had to be very polite and courteous in class. It is very objective. It is very vague and broad. Unless you narrow that down, I would not recommend having it in there at all, because then in that example, you would have a teacher feel they were disrespected and could physically grab that student and remove them from the class if they refused to leave. I don't feel that that is something that should be allowed to happen, because many times, often, if you're going from one classroom where it's super chill to the next one where it's really strict and not, sometimes you're going to slip. A student, they're kids. They're gonna be slightly disrespectful sometimes, and it's not a reason to forcibly remove a child from the classroom. If they are being like abhorrently disrespectful, cussing out a teacher, throwing things, pushing people, things like that, yes, absolutely, they need to be removed from the classroom. But a student just being disrespectful to a teacher and how they speak to them at first is not okay to remove them physically.
Well, go ahead.
Thank you, Madam Chair. So yelling, swearing, being violent, abusive, uncontrollable, would you agree then that this is all encompassed in just being disruptive? Because if a student is not really disrupting the classroom, maybe being disrespectful by sleeping, would all these other potential issues, would disruptive be sufficient? If the classroom environment, kids can't learn in there because of the behavior, is that sufficient?
Ms. McCoy?
Co-Chair Schuler, through you, thank you. Representative Kelly, yes, I think that would be all encompassing. I like your example of sleeping in class too. That's not disruptive. It doesn't affect any other student in the classroom, just the one that's not learning because he's sleeping, right? So I don't think that that would be a disrespect, physical removing thing. But if they are actually disrupting, the other students cannot learn because the teacher is having to focus on this student and their behaviors, whatever that may be, out of control, not a simple discussion, disrespect type thing. Yes, I think that would be all encompassing and could be included.
Okay, further questions? Go ahead,
Thank
Representative.
you, Madam Chairman. I would just like to kind of, again, talk about this same subject because I find just using the word disruptive to be very subjective, can be very subjective. I think some of the other words in here, not so much the disrespectful, getting rid of that, but some of these other words do then describe very significant situations and so are helpful. Would you agree? Because we're kind of, aren't we striking a balance here? It was teachers that wanted this. This is really, from our previous testimony, teachers felt they didn't have the clear authority to act. So we're trying to do that. I agree the wording can be worked on, but I just want to know, since we're entered this space, do you see some of these other words as helpful to kind of zero in on the word disruptive? How disruptive we're talking about? Because if subjectivity is the concern, which I think is valid on some of the words here, but to reduce it to one word doesn't really help us with that. I don't think. But what are your thoughts?
Ms. McCoy?
Co-Chair Schuler, Representative Lawley, thank you for that question. That's great. Teachers don't feel they have the authority for exactly the reasons I mentioned. They send students out and they get sent right back as if nothing happened. And that's not fair to our teachers at all. I do feel that some of the wording in this, yes, could be reworked. I think that disruptive can be objective. I think disrespectful can be objective. Violent is pretty clear. I think if you can work on the wording to narrow that down a little more, to discuss those abhorrent and escalated situations, to weed out those little petty things, I think that would be a much stronger case for this bill. And I think it would really help teachers in the long run.
We're all on the same page because I had scratched out 3 of maybe 4 of those words and I just had violent or abusive. So would you feel more comfortable if we just had those 2 words in there? I don't know if you have the bill in front of you or not, but does that pretty well give a teacher maybe or someone in the school district a better grounding for being able to remove a student?
Co-Chair Schuler, thank you. I don't have the bill in front of me because I closed my phone off. But yes, that would be much more clarified. I think that would give teachers and the districts much more guidance on what we're discussing. Like Representative Kelly mentioned, a student being slightly disrespectful because they said, "Hey, what's up?" instead of, "How are you today, sir?" isn't a reason to physically remove a child from the classroom. But if they are being violent, if they are throwing chairs, books, hitting people, cussing a teacher out to where they can't teach their class and all the other kids are not learning because of it, yes, they have absolutely every right to remove that student. But the parent should also be notified that the student was removed from the classroom, why they were removed, and then that partnership between the principal, the teacher, and the parent should all come together to discuss how to best move forward, which is why I think having that appeal option in there would also be beneficial to all parties.
And just to follow up on that same paragraph on page 4, that's probably where you would suggest that we would put that in with the parent notification, which I think a lot of districts already have that in place, but just to have it for everyone across the state, I think is very reasonable. So would that make sense to you to have that in that particular area where we're talking about removal of a student?
Co-Chair Schuler, yes, I would agree. That's a good place to put it. I would also comment, if I may. I know it was discussed about the parental rights bill and that it would cover this as well. It does not. It covers the changes in their mental health, their well-being and things like that, but it does not specify behavioral issues in the classroom. So I think by adding that in, it does strengthen this bill as well as the parental rights bill that we have in place already.
Thank you. Any other comments? Yes, Representative Bratton.
Thank you, Madam Chairwoman. Thank you for coming and testifying. What would you see is a reasonable amount of time? How quickly would you like to be, and do you think the people that you talk to would like to be notified after an incident?
Ms. McCoy?
Co-Chair Schuler, through you. Thank you, Representative Bratton. That's a good question. I would like to be selfish and say immediately, if my child is in your office and you are disciplining them and telling them they're going to be removed from the classroom, it takes 5 minutes to pick up the phone and call me and say, hey, I have Susie in the office right now. She just cussed out her teacher and we're going to need her to go home for the day. You could bet your bottom dollar I'm going to be there in 5 minutes, 10 if I'm across town, to make sure that Susie is not in class anymore and we're going through why she should not be cussing out her teacher. So I would suggest it's immediate while the student is in there, but I understand that sometimes when a student is out of control and you cannot get them to calm down and you have to go this route, sometimes it is slightly delayed. At the maximum, I would say by the end of the day.
Okay, thank you.
Any other questions for Ms. McCoy? Okay, thank you for your testimony. Appreciate your time.
Thank you.
Anyone else that would like to come up and testify on this bill, please come forward. Even though you've been here a few times, please introduce yourself for the record.
Thank you, Madam Chair. Brian Farmer with Wyoming School Boards Association and Dr. Brown with the Wyoming Association of School Administrators. He's going to fill in for me where I miss some context, but we wanted to share with you some concerns regarding the operationalization of this bill. What does it look like for a school district to implement this bill, and concerns that we have? Certainly in the broad overarching concerns, you've addressed many of them. In many ways, this bill is very prescriptive. It does not have a lot of flexibility. There are certainly concerns pertaining to due process. You've talked about the need to be aware of the rights of the special education students and the manifestation hearings to determine whether or not their disability was a contributing factor to the behavior prior to implementation of discipline. I think I've heard the comment, does it go too far? And a question that sort of rings with me that was asked in Casper, what does this bill add that we can't already do or don't already do? And I'm not sure that there's a lot that it ultimately does that we can't already do. So with that, Madam Chairman, I'd like to walk through and talk about some of those concerns beginning on page 2 and pointing out structurally, again at line 16, it says the rules or policies shall. And so as was pointed out by Senator Rothfuss, that means everything under that is prescribed. It must happen. There's not flexibility. So the policy must address those things. So line 18, provide all school district employees with the authority to enforce those behaviors. And I think that issue has already been talked about, so not going to retread that territory. But there is that concern of, are all employees reasonably trained in how to enforce discipline, and what does that look like? It certainly is different from group to group.
Just a common example would be the same thing. If you have a student that's disruptive on a bus, it's pretty hard to kick them off the bus at that time. You have to deal with getting that kid home, and then we'll deal with it. But taking a kid out of a classroom is different. So if a kid is disruptive on my bus from this, that bus driver would have the ability to just kick the kid off the bus. So I guess that's a practical, I'm kind of going down the road where Senator Rothfuss was, but I wanted to give an example of kind of how, looking at it through superintendent's eyes, we're a little concerned about some of that.
Madam Chair, moving on to page number 4, there's been a lot of discussion at line 11 about the different descriptors of student behavior. I think we know that when that student goes nuclear, that we want to be able to do something to take care of their behavior, that we want to address that. But how subjective is that? At what point is the student just reacting to their environment, and what point does it become something that does merit behavior interventions? And I think some of the discussion you've already had over those subjective terms, just want to reinforce and reiterate some of those. But Madam Chair, very specifically, I want to point out lines 14 through 19, which is essentially the language about the reasonable use of force. Now, from a statutory construction standpoint, you have your paragraphs and your subparagraphs, your sections and your subsections. So anything that is in that lower order only applies to that lower order. And so that reasonable use of force only applies to this I here, this removal of the disobedient person. And so it does not authorize reasonable use of force in other instances. And I guess my concern that I plan to address later is that that language maybe is better somewhere else in the bill, because it is very narrowly construed to only apply to the removal of that student for this disruptive behavior. Madam Chair, moving on to page number 5, when we look at the lines number 8, 9, kind of in that area, it says that start with line 6, prior to the imposition of any behavioral modification or consequence pursuant to section D of this section, the school principal, school district superintendent, or board of trustees shall consult with the employee. So, Madam Chair, first of all, there's a concern with the board of trustees consulting with a teacher at this point in the process. The board of trustees are usually reserved to be the final actor, the final determiner of action. And so you don't want the board of trustees involved at this initial phase. They're the appeal. They're the final process. If they're involved here, they cannot act as that unbiased appeal. And so you don't want your board of trustees involved at this early phase. This is the phase where the administration is determining the appropriateness of discipline.
Just a couple other things there. And all your districts have handbooks, rules, regulations. They all have that spelled out. They probably have a matrix. They probably have they have it appropriate for the age level and where the students are at. It's totally different for some kindergarten kids to come in from the playground and a couple kids tackle each other than two high school kids getting into it in the hall. And it's not going to be the same. And so if we have to go back and consult with that teacher, we can have disparate punishments for different students. And we want to keep that as consistent as we can. Otherwise, we're putting ourselves at jeopardy of being sued on the other side of that. So I guess there has to be a way of everything being consistent there. And again, we want to make sure that our teachers are safe too. And I would say if the principal's not doing what they're supposed to be doing, we need to deal with the principal. If the teacher's not handling the students appropriately, we need to either get them some training and get them to where they can handle students appropriately, or we need to do something with them as well. Sorry.
Madam Chair, if I may, now on lines 11 through 16, it basically says that if the final punishment imposed is different from what the teacher wanted, now you need to tell the teacher about that. And that seems to be a little bit tricky, particularly when you look at the last sentence, lines 16, 17, 18. The employees shall be informed of all actions taken to address the student's behavior. Madam Chairman, in many cases, that will violate FERPA, the Federal Education Privacy Law, because FERPA is based on what the law calls a need to know. There may not be a need to know under that federal privacy law. And so there is definitely potential for conflict between your federal privacy law and that mandate of the statute. So concern with that. Madam Chair, moving on to page number 6. I think you have already talked about lines 8 through 9, the concerns about the written consent of the teacher necessary to return to the classroom. Certainly that can be difficult to implement. I think everybody views that from the lens of what does it look like at my school. If I'm from Casper or Cheyenne, there might be lots of options of where else to place the student. If I come from a medium-sized district, then maybe I can conceive of other options. But in our smallest of districts, there is one class. And if they don't return to that class, then they're not returning to a classroom. So what do alternative educational opportunities for students look like? Certainly that is considered under suspension and expulsion, but in many cases, districts look to say, how can we keep this student in school within an appropriate restricted environment? Maybe it is with a one-to-one teacher aide. Maybe it is with some other sort of disciplinary action. But here you have this very prescriptive, and it basically is what it is. The kid doesn't come back to the classroom unless the teacher says it's okay.
I'll talk about lines 13 and 14. Dropout prevention and academic intervention programs are not usually used as disciplinary measures. So that was just confusing, and I'm not exactly sure what they're talking about there. But usually we use consequences for discipline and not a change in their academic placement.
So, Madam Chair, I think where interventions are necessary, those interventions are going to take place regardless of the disciplinary action. That is not really a consequence of the discipline. It's based on the need of the student. Madam Chair, page 7, line number 6, there is a word immediate assistance. So you're telling the school district that they must provide immediate assistance when an employee requests for that. And again, that's a somewhat subjective term. What does immediate assistance look like? So if you have a superintendent who's dealing with a bomb threat or something very significant, and a teacher asks for help with a student who's throwing a temper tantrum, that superintendent or principal, whatever, must provide immediate assistance to the teacher dealing with the student having the temper tantrum and may not be able to deal with whatever other issues they're attending to. So I think the time word is a tough word for us to operationalize.
Would probably be better to as soon and as reasonably possible or something like that.
Madam Chair, similarly on lines 10 through 13, it talks about high-quality professional development, a very subjective term. What is high-quality professional development? To provide students with a high-quality, adequate education. Again, a very subjective term. Should that just strike both of those high qualities? And then on line 12, provide students with an adequate education. Would suggest striking both high quality in both instances. At lines 14 through 17, each school district shall ensure teachers and staff have input on the decision and implementation of that professional development. So not entirely sure what's anticipated by this. Again, using Senator Rothfuss, groundskeeper, custodian, their input on the professional development for what does the use of force or the disciplinary procedure look like. How do we ensure that we're getting that from teachers and staff?
Yes, question, go ahead.
Thank you, Madam Chairman. When we talk about like professional development for teachers in this area, what's kind of the range? I know we talked about, was it the maths training, one of the trainings a couple meetings ago, but what is the range of these trainings that a school would have to pick from for their teachers to go through?
Mr. Farmer?
Madam Chair, that's a wonderful question. And I think if you could provide a drop-down list, it would fall all the way to the floor of the mandatory trainings. So you have everything from bloodborne pathogens or something like that. You have training around sex education, like how to make sure that
Sexual harassment.
Sexual harassment education is in place. So all of the mandated training that has to happen is voluminous, and then you have 10 professional development days to get all of that stuff in. So making sure that all of that happens, this adds one more requirement to that list of mandated trainings.
Thanks. That has been one of my questions on how many mandated trainings that we have. I don't think I phrased my question the right way. When we're talking about doing a training on what they're talking about here in F, to ensure teachers and staff have the ability to provide students with that, I guess I was thinking a training specific to, but that's not really what it says here, specific to like kind of the discipline and how to handle that with students. I guess one, is that something that we have in place as a mandatory training right now? And two, what kind of options would schools have to choose from for trainings in that specific area?
Mr. Farmer or Mr. Brown, either one?
Madam Chair, I'll take that one on a little bit. And I'm going to say it's very broad. There's everything from canned trainings out there. A couple that I would just pull off the top of my head is MANT training, which is restraint training that you can use. There's also Boys Town model, which a lot of people use. Then I would say that most districts get people trained in those, and then those people are the trainers for the district. And so then you would train everybody in the district. Usually you train everybody that's around kids in what they are supposed to appropriately do. Not everybody gets the same level of training. Again, if it would be a custodian or library aide or maybe a bus driver, they would refer that to somebody else to deal with the kid based on their behavior normally. And again, I would say that reading the bill as I read it right now, that would not be an option, that employee would have the ability to deal with that kid the way they saw fit at that time.
Follow up, or are you good? Okay, Representative Bratton?
Thank you, Madam Chairwoman. Real quickly on page 5, line 16 to 18, you mentioned that you were concerned that there would be a violation of FERPA as far regarding privacy. And I would like a legal opinion from LSO on that.
Well, so do you mind doing that?
No,
Or do you
certainly.
need some time on it?
Yeah, no, Madam Chair, Representative Bratton. I disagree with Brian's legal opinion. That happens when you get 2 lawyers in a room or 10 lawyers in a room, they never agree. But I do believe that there is a need to know basis for the teacher with regard to a student that was in her classroom and the discipline relates to her. He is correct that the law provides for a need to know basis. But I do think the teacher needs to know, particularly if they're going to place that student back in her classroom or his classroom, a teacher's classroom.
All right, thank you.
Yes, Representative Lawley.
Thank you, Madam Chairman. Most of these provisions you've talked about are things teachers specifically came to us over the interim as we've kind of wrestled with this topic, brought up as things they felt they needed, that they weren't being heard. They didn't feel their administration was always supportive. I'm not saying every time, but that was the message we got loud and clear. I agree with you sometimes on the language maybe getting better, but how do we handle that? I mean, so we've got administrators saying, no problem. We don't, teachers don't need to have the specificity in this bill. We got it handled. But that's not what we're hearing from teachers. I'm not hearing it in my district from teachers, but we also as a committee throughout this interim heard that. So that's what I'm wrestling with is I think some suggestion on language is very helpful, but yet the idea that this is kind of not needed, I don't even know why it's here. Those kind of comments are concerning a little bit to me because we are hearing from teachers. So all is not well in the discipline area, whether this bill is the best vehicle or it needs more. I think it does need more work personally, but I'm just trying to wrestle with that. So, we got this administrative level, your guys represent, which I appreciate that level and the view of that. But many of the issues were brought to us by teachers and they're very real. In some districts, significantly real and of a high level of intensity, some of the problems they're facing. So could you address that for me?
Madam Chair, I think we would both like to address that question. And I think that, first of all, the suggestions that we're offering are primarily the operational difficulties in implementing this statute, not conceptually whether or not these are important areas or things that need addressed or don't need addressed. I think it is a concern for how do you operationalize statutory language? Is there a lack of clarity or are there suggestions for striking certain words or certain phrases is primarily what we're attempting to do at this time. The overarching concern with regard to the bill is how does this bill provide a vehicle for addressing those questions, those issues versus some other solution that might more directly address those sorts of things. I would also say that I think when teachers come to their administrators, that is often the response that an administration has. And absolutely from a school board, when a school board hears the concern of a teacher, then they're going to take that seriously and say, how can we address that? How do we consider the overall scope of how our employees are able to perform their job? Because that is the only resource that the district has is their employees. And so that education of the student being the paramount job of the district and our employees are resourced to do that, I would feel like it is necessary for those things to be addressed. And if it's not being addressed in a district, I certainly understand the legislature having discussions about how can the legislature provide greater direction to the district.
Oh, go ahead.
Madam Chair, Representative Lawley, again, I'd go back to the question, is this overkill of where we want to be? A place to start, at least from my opinion, would be to ask each one of the districts to put together their own policy that would take care of teachers who felt like students were being too disruptive. And I don't think that districts would be opposed to that. And I think similar to what our parents said, that it would be done locally and by each district. And if there were enough parents that wanted to have reports, they could ask for that to be there. But that might be a place to start, rather than, when I read this, it's shall, and this is the way it's going to be. So it really, and I'm not saying we don't need it. Again, there are poor administrators out there that don't do the right things to take care of kids, but we have teachers. When I was a principal, I had a teacher, if a kid didn't bring a pencil into his math class, he sent him to the principal's office. I didn't give him a sucker, but I said, here's a pencil. Go back up and learn your math. I mean, so it goes both sides. And I think, in my opinion, we're to the shall already here without saying, will you develop your own policy locally to help protect your teachers from disruptive kids and other students from disruptive kids in a learning environment?
Follow up, go ahead.
And I do appreciate both of those answers. It does help me a little bit better understand. But what we can say is the system as it exists now isn't working like it should. And part of that's the changes and the challenges of discipline are escalating fast. And but this was the #1 interim priority of this committee, and it came from the Department of Education. And then we had a lot of input from that teacher level. So that's where I'm struggling of how do we help the teachers in a meaningful way? Because in many districts, that's just not happening. And so I wonder if well, let's just take all the shalls out will actually be that effective. But maybe there was some we could take out. I don't know, but I'm trying to find a solution here because there is a problem. The suggestion that we might be trying to solve something that's not really a problem. We've had too much testimony. At this third interim meeting, we have already a record. And I don't know that this is the best solution. So know that but I'm trying to find it. Where is that sweet spot of effectiveness that addresses what we're hearing and what we know is happening, and that these are challenges for the administration and the teachers alike. I mean, nobody wants these issues to be here and to be so intensified. So I just wanted to say that as a comment to you. And if you want to make a comment also about that, but that's kind of where I'm coming from. Again, I'm not sure this exactly hits the mark either. Definitely some of the language is too broad. But I'm not convinced either that the other side of it of, let's just say districts, hey, respond to your teachers. I don't know if that's going to cut it. So again, I just put that out there.
Representative Bratton, I believe, had a question.
Thank you. So in addition, the problem is the teachers are afraid of blowback from their administrators. They are not reporting because they do not, and I have heard it from teachers all over this state. I have heard it from parents who talk to the teachers because they have concerns about what's going in the classroom. But that is a big part of the issue is, you mentioned they should, go to their principal, they should go to their school board, but they're afraid that there will be repercussions from that. Some of them have actually seen and told me the repercussions, and they don't even want me to use their names or mention their school districts. So that is why we are trying to come up with legislation that addresses that. What are your thoughts on that?
Either one of you, go ahead, chime in.
Madam Chair, first of all, I would say that we agree that discipline is an issue that folks in education at all levels are dealing with disciplinary challenges. Discipline today looks different than discipline 5 years ago, 10, 20 years ago. It blew me away the first time I heard about abusive language that kindergartners use to teachers. I couldn't fathom something like that happening, but I know that it does. And I hear it from folks as well. And I do believe that it is not appropriate to paint with a brush one way or the other to say it's not a problem or it's not being addressed anywhere. I think we have a big state, and with different districts are addressing it in different ways. So the challenge is, how do we find directive to our districts that helps to provide solutions? And so I don't disagree with the endeavor of the legislature. Our challenge was really just in responding to the bill in front of us, offering concerns for how does a district try to operationalize that? And I think every time I have dealt with concerns that are raised, I never pretend that I know the whole story. I hear pieces, and I know that there are other pieces. I've done investigations, and even after investigations, I don't assume that I know the whole story. So it is important enough that if somebody had concern to bring it forward, that it deserves to be looked into. It should be examined. And I wouldn't know or wouldn't pretend to say that every case is dealt with the right way. I think that administrators and districts will do their best to respond to the incidents that come to them. And to the degree that teachers need more support, I do think that the process that we have in place is to make those requests of administration, make those requests of school boards. And if they're not finding that they're receiving that kind of support, then I don't blame them for seeking alternative ways. How can we do that? Through legislation, through a new school board. There are different ways to try and affect the outcomes we want. I'm also aware that in my tenure as an elected official, I generally heard about the things that weren't working well, and didn't often hear about the great things, the things that were great. Very, very rarely did somebody come up to me in the grocery store and say, "Hey, I just want to tell you about how awesome something is." So I did hear the concerns, and those were the things that I needed to attend to. So it is tough. I think you hear those concerns, you need to address those concerns. And I think it is a partnership. I think administration, school boards, legislature, teachers are in this together to do the best for all of our students. When we talk about the disruptive student, we certainly have a due process obligation to that disruptive student to ensure that we're providing them their education, but we've also been talking about the rights of all of the other students. And so all of this becomes balancing test. How do we find that right balance?
Mr. Brown, any comments on the question?
And I'm not going to add a whole lot, but I think, again, it's a balance going back to even working with the parents and making sure that we keep them involved. So again, and I'm not saying it's not a problem. I'm not saying we don't need it. Trying to react to what we have right now. And I guess I know that my superintendents would put a group of people together to work with whoever you guys wanted to try to come up with a solution or a model policy or a couple, 3 model policies that we could use to work on that. It's just kind of how I've read this. And I mean, just like the bus driver kicking the kid off in the middle of the deal. I just, reading it, I think that they have the ability to do that. And so I just want to make sure that you guys are aware of how we're reading it. So again, I'm not saying that we shouldn't deal with it. And I guess want to make sure that we have everybody at the playing table whenever we're talking about it. Again, I think I've had to dismiss principals because they didn't handle things well. We've had to dismiss teachers because they haven't handled things well. And I'm not gonna, I guess I'm not pointing one way or another. I mean, we're here and we'll help. We'll do whatever you guys want, give you what information you want. But yeah, we'll help try to solve the problem.
Thank you. Go ahead, Senator Office.
I want to ask a question in a very different mode. You know, we've been talking mostly about the severe cases of disciplinary problems here. I'm going to be concerned for a moment with the much less severe, where I think maybe some things can be done that are deal with those effectively and may prevent some of them from progressing to more severe cases. And what I'm thinking about is a situation where it's encouraging the teacher or the other district employee, and frankly, the place I've seen it really used was in school bus driver, dealing with the parent directly, trying to informally get the situation dealt with before it reached the kind of serious thing that most of this bill is talking about. And what I'm thinking about, Madam Chairman, and I want their opinion on, is if you look on page 3, starting at line 11, there's the provision that provides school district employees with authority taking the following actions. And adding a new subhead under that would essentially read, informally discuss behavior and discipline issues regarding a pupil with that pupil's parents. So that one of the things they had to do was give their employees the ability to talk directly to the parents and try to head things off in an informal thing. And my observation is I think it would work well most of the time, and the administrator would have to deal with the occasional knucklehead parent who was really the problem, that says my kid can do no wrong. And those do occur, but would it be worth putting in something like that to give a push for that kind of informal resolution of most of the problems before they get to this stage?
First.
Either one of you have a.
Madam Chair, I think we have, first of all, some amazing bus drivers in our state. These are some of the best individuals at dealing with human behavior in many cases. So that's a great example to utilize. I think informal resolution is certainly a part of the process of addressing discipline. If you can informally resolve something, then that can be helpful. I think the one challenge operationally is if a child engaged in some behavior on the bus that could be construed as sexual harassment or something like that, that pushes us into Title IX. And that doesn't give us options about informal resolution. If there is something that is a mandatory sort of action, then we don't necessarily have the informal resolution as an option. So I would say the majority of the time, that's great. There are Title IX is the only thing that I can think of off at the top of my head where we don't have the option. If something can be construed as a Title IX issue, then it must be investigated and a formal process must ensue.
So all 3 districts that I've been the superintendent of, that was our first route. I would say there are some folks that didn't have some skills that I would not want them doing that as employees, just because of the skill set that they had. But certainly for my teachers and instructional aides, the request was to make that informal communication with parents, even having a formal meeting with parents prior to getting where we want to be. So I would say, yeah. When we look on the other side at the board level, whenever I did board training, one of the things that we wanted to make sure that we communicated to our community was the chain of communication. And that was trying to solve the problem at the lowest level, whether it was with the teacher, or with a coach, or with whoever the student had an issue with. So yeah, I think that that's important. And I think that most districts try to do that as much as they can.
Okay, Senator Rothfuss has a question, but I'm going to jump in front of him real quick. So, my mind sometimes wanders and I don't want to forget, so I'll come back to him. But, and I totally agree with Representative Lawley and Representative Bratt. And I've been hearing those same complaints, and we have from, kindergarten teachers, which it just blows me away. So I think we can do some wordsmithing with the bill, and I appreciate your comments. But one question that I think might help, and it might help with Senator Rothfuss and maybe the consternation of some others, was when we talked about all school employees. What would you feel if we just added educators? Would that help? Because this bill, the bill, as both representatives mentioned, it's about teachers dealing with discipline throughout the state. And I think we kind of went off the rails a little bit. We started talking about the custodians, and I will tell you this right now, if I had a student, my own child, that was getting, the heck beat out of them, I would like anybody to please step in and help. I don't care if it's a bus driver, a maintenance guy, custodian, whomever. But I think we got to kind of keep the focus on teachers and what they're dealing with and their discipline. And I think we've had some good discussion, but how would you feel about if we just switch that back to just educators? That would take care of your paras, your instructional coaches, and so on and so forth. What are your thoughts on that?
Madam Chair, word choice is obviously a policy decision for the legislature. Educators could be those that are involved in student instruction, but it is difficult. Senator Scott's often used the example of the bus driver. And so is the bus driver the educator as well? Certainly in the informal sense, they can be. I think it might be more appropriate to use something like those responsible for supervision of the children, those who are directly responsible for the supervision of students.
Mr. Brown, do you have a comment on that?
I don't have anything to add to that, ma'am.
Okay. Senator Rothfuss.
Thank you, Madam Chairman. So one of the, this conversation has been a good conversation, and I think it's clear that there's an interest in resolving a problem that has been identified statewide. There's a lot of concern by our educators that they're not taking seriously when they have classroom management issues, and that those problems lead to continued challenges for them. So we've heard that identified, and this legislation is intended to address that. What I'm not hearing and want to ask about is whether there are any statutory problems in your eyes, and I should ask others this as well, or whether it is implementation problems. And I even think about the bus driver, the custodian, all of the things that we've discussed, the scenarios. I'm not sure there's any problem with statute right now. I think everything's okay in statute, but the policies that districts have to carry out statute might have flaws and challenges. Am I missing that? Am I wrong, or am I right on that?
Mr. Farmer or Mr. Brown?
Madam Chair, we were at page 7, line 19. I have a number of other suggestions identifying problematic words or phrases, sometimes with suggestions for improved language. But when we come to the end of the bill, I specifically have a suggestion that would address Senator Rothfuss's comments or questions, concerns.
Madam Chairman, and to be clear, I'm not saying statutory challenges with this bill. I'm saying existing statute. Do we have anything that existing statute is insufficient to allow a district to resolve this problem?
Mr. Farmer?
Madam Chair, I'm sorry, I misunderstood. I think that's what I intended with the general comment that I started with. There's nothing with our current situation that would prohibit us from addressing many of the concerns that are in place. So as you talk about how do you address behavioral management in a classroom, on a school bus? Are teachers able to remove students from classrooms? Are people able to enforce the rules of a school district? I don't believe that there is anything in statute that provides a stumbling block that you can't already do those things.
So, Madam Chairman, then if we're at a point where, from a statutory standpoint, we can achieve the outcome we want, but from a reality on the ground standpoint, we're not always achieving it. And we can't assume that we're always failing. I assume that there probably are many classrooms, many buildings that are achieving it. Then the question comes down to, well, what's wrong and what should we fix? I agree with Representative Lawley that we've waited a while and it hasn't been fixed. So maybe there is a role for us to nudge in some way and to say, you know, thou shalt solve this problem in some capacity. But the key is, how would we say that? And a couple of things come to mind that this bill doesn't address. This bill provides more explicit power to all district employees, but it doesn't seem like it's a power set that they need. It just seems like implementation is the barrier. So my question gets back to a conversation we had years ago, really, with accountability in education, where a lot of the discussion was, we're doing something to address teacher accountability and ensure that our teachers are of the highest standards and have sufficient professional development to do their job. And then there was a side conversation during that whole exercise about the fact that what we really should focus on is building leader accountability and ensure that our building leaders, our principals, our vice principals, anybody else who's a building leader, has sufficient professional development and expertise to do their job well. And heard at the time that oftentimes that is the case and the building goes very smoothly. Other times it's not, and there are challenges. So my question, and I should probably ask others as well, but I don't see enough like superintendents and others to ask. How much of the challenge is just that sometimes we have building supervisors that aren't good enough yet at implementing appropriate responses when there needs to be an intervention? Because I do see the case often being teacher sends Billy to principal, and under best of circumstances, they get handed a pencil and they go back and they do their work, but perhaps under some circumstances, it's insufficient, and that's where the challenge is. Is that something that we should be focusing on? And I'll just pause there. Is that part of this problem? And we don't seem to have talked about it.
Madam Chair.
Either one of you, feel free.
Two answers to that. The first is, when we talk about what's missing, I think we have said before that having sufficient behavioral interventionists within buildings is missing. There's a resource still missing to address behavioral intervention. So we're talking about how can we make all staff behavioral interventionists, which obviously takes away from their other duties. The other piece of that intervention piece that's missing is day schools or other types of programs. Some exist throughout the state, but that's when a student has to be removed from the traditional classroom, placed in an alternate environment, and offered educational opportunities in that other environment. Those sorts of resources, when engaged, can really help with those disruptive behaviors and implementations. As far as principal or leader accountability, in Chapter 29 of Department of Education rules, it is mandated that all educational leaders must be evaluated annually. And so they are evaluated on an annual basis, according to that Chapter 29 rule. And it's not just generically evaluated. There are specific criteria within Chapter 29 as to how to evaluate principals. Now, we've talked about a teacher shortage, and we know that there's not lots of teachers out there. That trickles its way up. So as we face teacher shortages and teacher challenges, there become difficulties in hiring principals and administrators. And so candidate pools have certainly shrunk for those positions. Finding the right people to put in those positions has become challenging. And then what is the support offered to those individuals becoming yet another challenge? I know that the superintendent has had some focus on ways to support principals. The Superintendent's Association has provided good support to superintendents, but I think the state has identified at that principal level, our principal associations their executive directors are part-time folks, retired principals, or folks serving in a current capacity as principal or staff. And so resourcing those organizations to provide that support to a principal to say, how do I manage this situation? There is a gap in the state. How do we help principals to be best at their job?
And just getting into that aspect, Madam Chairman, part of it I think that you hinted at a moment ago is even if that principal is highly trained, has all the tools they need to manage a circumstance that arises, they probably don't have the time available necessarily to carry things out exactly as they want. It sounds like that's what Boyd wants to address.
So yeah, and I've been a principal before.
Yeah.
I'm hired to be the lead instructional person in that building, not to be the disciplinarian.
Right.
Not that I don't have to handle discipline, but that's my job, is to be the lead instructional person. Go around, observe teachers, make sure they're doing what they need to have proper instruction, make sure that they're doing assessments appropriately, talk to them about professional learning communities. What do we want students to know? What do we do whenever they know it? What do we do when they don't know it? So that is the major part of my job. Helping manage discipline is another large part of my job, but I've got to, you guys and my board is going to hold me accountable for student achievement. So I think having some more behavioral help of people who can manage some of that would be beneficial. I mean, it's very difficult to try to make sure that you've got everything running smoothly instructionally across your school, and then trying to make sure that you're helping manage everything managerially, from the bell schedule to everything that you have to do managerially, not instructionally, which includes teacher behavior and student behavior. So if a teacher's misbehaving, I have to go and investigate that and deal with that. If a student goes to the point, and we usually have levels, if it's this level, you handle it in your classroom. If it gets to this level, you come here. So if it gets to the principal level, then it is my job to deal with it. So again, I think having the time and resources to do all of that is very difficult. And I would say it's easier in some senses in smaller schools. I was the principal and superintendent whenever I was in Claremont. I knew every kid individually. I had one that I would bring to my office whenever he melted down. He would stay in my office and want to go back to class. So I think it's trying to balance all that all the way out. And teachers have up to 25 kids in their class. And if that one kid just keeps getting after it, yeah, it's difficult for them. So I think having the support that we could do, if I had a behavioral person, I'd say, go down there and help deal with that. Let's put a behavioral modification plan in place. Yeah, that might help. Sorry, that was a long answer to an easy question.
Sorry. And Madam Chair,
you have a follow-up?
if I can ask for 2 short answers then, so that I can move on, one from each of you. I don't like this bill. I don't think this is the answer, but I do fully understand the need for something. And I'd just ask each of you very briefly, what is that something? What should we be doing to get the outcome that I think is pretty clear? Everyone understands what we want, and this bill doesn't get us that. So do we have is there a short answer to that question?
Who wants to go first on this one? Mr. Farmer.
For me to get a short answer, that's why I was waiting for Boyd to go first.
I totally failed last time too.
I think the short answer, what can we do, is continue the topic to the next session, to specifically look at behavior intervention strategies that are effective, and see what we can learn from those intervention strategies, whether we're identifying missed resources, missed best practices, model policies. If we are able to identify the districts that are able to address these, then it helps us to say, is this because some districts just don't have the resources, the will? It helps us understand the problem better. And in the meantime, certainly with these conversations, there is encouragement of the legislature, districts, you need to continue to work on this.
Madam Chair, Senator Rothfuss, I would say that it's not something that we can solve in a vacuum. I think we need to get everybody together and have, similar to what we did with the reading. I think that turned out pretty darn good. But if we can get teachers together, administrators together, principals together, parents together, and put some thought to that, I think we can. Again, I think looking at districts that are currently being very successful at dealing with this probably would be a good place to start once we get moving forward with that. So yeah, I would agree, just getting everybody together and working forward with everybody there.
Okay, if you guys are good with where you are, we'll open it up for further. Oh,
Madam Chair.
Page 7.
Oh, okay, you still had more.
I
More to say.
will reduce our.
I was hoping we could
comments to
stay on schedule, but it doesn't look that way.
Essential.
Make it quick, okay? Thank you.
Yes, ma'am.
Appreciate your testimony, though.
Madam Chair, page 7, lines 19 through 20, and page 8, lines 1 and 2, talks about the teacher planning period already been identified as potentially problematic here. I don't know that you've considered, but a lot of our high schools operate on a block schedule. So if you have 4 periods in a day and a teacher's getting a planning period out of each day, a quarter of their time would be in planning periods, which I'm sure they would love, but becomes very difficult then to offer the full complement of classes. I would suggest changing that language if you choose to keep it, striking all of line 19 and the word instruction on line 20, and having the word planning time added. So it would be planning time for teachers with students enrolled in teachers' classes, and then strike the remainder of line 1 and line 2 and say as determined by district policy or contract. So that would be planning time for teachers with students enrolled in the teacher's class as determined by policy or contract. Oftentimes, the issue of planning time is addressed in a teacher contract, but it may also be addressed in a district policy. So if you choose to keep that, that would help specifically with the issue of a block schedule. Madam Chair, I know these comments are not the favorite because I'm pointing out an issue with not necessarily a solution, but page 8, line 10, defend and support. I'm not entirely sure what that means. Does that anticipate a legal defense of a teacher who has reported information related to the violent crime? So I'm just unclear as to what defend and support means. Similarly, on lines 15 and 16, it has the phrase likely to occur. I'm not sure how a school district would know when physical violence is likely to occur. That becomes very problematic. I would suggest striking that language. I will skip on page 9 comments about reporting because reporting has been discussed. But a separate issue, Madam Chair, comes at the very end of the bill. that I would just briefly like to address, and that's in the repealers. And so it's most helpful, I think, to look at page 11, lines 1 through 10, which talks about the language being repealed. So the first B is basically about corporal punishment. And I think everybody says, yeah, let's get rid of that because we don't want to give kids spankings. That's not good stuff. Madam Chair, if you just struck the word corporal, I would suggest keeping that, that language. So it would say teachers, principals, superintendents in each district shall be immune from civil and criminal liability in the exercise of reasonable discipline. So previously I had talked about the language using use of force back on page 4, line 16. If we keep this language, then you're protecting folks from claims against them. If you don't want to go so far as to keep the immunities, then you could say that those district employees are authorized to use reasonable force in the exercise of reasonable discipline. So either way, I would encourage you to keep B. Let's get rid of the notion of giving spankings by striking corporal. And let's keep a notion that at the higher order, this is the appropriate place to talk about what is appropriate discipline and what kind of protection do we offer the district. The immunity as currently exists or the right to exercise reasonable force in the exercise of reasonable discipline. And the final is keeping that C. That repealer C there says kids can't be denied a diploma, but sometimes we're going to say they haven't earned their diploma until they've paid all their indebtedness to the school. So the way this typically plays out is a kid gets to graduation and they've got some fines. Maybe they didn't turn in textbooks and they owe for the textbook. Maybe they have school lunch debt. Maybe they have some other indebtedness. They didn't return their football equipment. And so the way the school district gets them to pay it back is say, pay your fines so you can go to graduation. If the school district has this removed, the school district's only recourse to collect on those is to essentially go through a collections process. I really don't want to turn kids over to collections, for fines or fees that they have at a school district, but that either the school district eats it or they go to the collections agency to go after kids. This is a much simpler solution than that. So I would recommend not repealing B or C, keep those because they do have good reasons for staying in.
Mr. Brown?
As a principal, Madam Chair, excuse me, that was rude of me. I have seen students with a tuba, a trombone, and a baritone that they didn't turn in at the end of the year, which was worth quite a bit of money. And to get it back, we held them until they either brought the instruments back or they paid for the instruments, and then they could get their diploma.
Okay. All right. Any other comments? All right. Thank you, gentlemen. We've got about 10 minutes until we're supposed to go to lunch, but we're going to keep it open just for a bit longer for testimony, and we may have to go ahead and take lunch and then come back. But any other comments from anyone in the room on this bill? Okay.
Madam Chair, if I could offer one
Certainly.
Observation that I didn't speak to earlier. With regard to removal of a student with reasonable force, there are two statutes that are relevant to that. 21-202A, Romanet 32. That requires the state superintendent to have rules regarding seclusion and restraint. It also requires that she review all school district policies, and that does include removing a student from the classroom. So that's sort of an overlay of this, and this bill would not, number one, contradict it, but number two is another safeguard with regard to the provision in the bill. And then that dovetails into the school district's responsibility, and that citation is 21-3-110A, Romanet 31. And that also requires that you notify the parent and that the school district has to submit their policies to the Department of Education. And in the event that those policies are not sufficient, the Department of Education can require corrective action. And that statute has been in place since 2011 and also requires the state superintendent to have rules. So perhaps the department could speak to that. I don't know how it's being implemented.
Okay, anyone else that would like to testify on this bill? All right, we can go ahead and close public.
Madam
testimony.
Chairman.
Oh, sorry.
You've got one
Somebody
online.
online? Okay, sorry. Please introduce yourself.
Hi, my name is Lindsay Adam. I'm attending virtually from Pinedale, Wyoming, Sublette County School District number 1. I apologize for being the one thing between you all and lunch. I have been a teacher in Wyoming for 17 years, teaching Spanish and English as a second language. 2021 District Teacher of the Year. I was on the Superintendent's Teacher and Recruitment Task Force. I was a member of the Level Up Alumni, which Superintendent Megan Degenfelder did come to us last spring for input before putting this bill together. At the time, our major message to her was teachers don't want a bill that comes through that's punitive for students. We don't want school discipline to turn into a talk about punishing students and like they're the problem. We want solutions. That being said, I read this bill for the first time this morning, and I do read it as a peace of mind for teachers bill. I don't want to throw the baby out with the bathwater because it's not perfect. I, as a teacher, have had many times where I'm concerned that just because my school district has a certain policy, well, policy is not going to protect me if it comes to laws and parents are suing. I will say that there is a culture of fear among teachers. It's gotten very strong since COVID. You know, we all bent over backwards to teach kids from wherever they were. And we came back to the classroom thinking that we were going to be the heroes, and instead we were the problem and we were indoctrinating students. So the Parental Bill of Rights kind of told us that. The Don't Say Gay bill told us that. The federal level of dismantling of equity inclusion rights for our students told us, you as a teacher don't really have the rights to stand up for yourself or your student. And to me, this bill gives teachers some peace of mind of what rights they do have as a teacher. So I have a ton of notes. I apologize, they're not in order. I will try to reference the specific pages. I do want to start saying first, page 3, item A. No one's mentioned this. I really appreciate that it gives us a legal right to enforce cell phone policies, because every school has policies. But I can't tell you how many times my principal has lamented that, you know, even though I have the right to take a child's phone and turn it over to the office, if the parents come in super angry about us interfering with their child's personal property, he doesn't feel like he's going to win that should it go to court. And we have to back down every time. And that has just been, I don't think we should be a state where we have a state law banning cell phones in schools, but we should have something that supports the teacher's right to enforce the policies that parents have signed off on every year in the handbook. Page 5, item B, Roman numeral 2. Just to reiterate a few things that have been said, I do think it's important that teachers get written notice for the consequences that a child is receiving if they have been removed from their classroom for violence or repeated disruption. Teachers are constantly reporting behavior, whether it's just a report or asking a child to go to the office. Almost never do I get any kind of follow-up of, was there sort of any action taken? Is this going to improve? It's just, oh, here's the kid back again. And I agree with what the LSO said. I think that a teacher's right to a workplace free from abuse and harassment should to some extent trump a student's right to privilege, depending on what the student was removed from the classroom for. When we get to page 4, item B, talking about all district employees having the right to use reasonable force, I fully support removing the line about in the case of ruining other students' opportunity to learn. I'm not going to put hands on a child because my other students aren't learning. I will remove all the other kids who are being safe, and we'll address that later. But I do think there should be somewhere in here that says reasonable force is allowed in the case of violent, abusive behavior, or if the child is being unsafe to himself or others. I am a foster parent. I've had 21 children. We had a 9-year-old who was extremely violent, and just a little bitty thing. When he was in 3rd grade, he had so much behavioral and emotional issues. He would go on almost benders where he would start tearing books off the walls, and he was already in a very small special ed classroom most of the day. He would tear books off the walls. He would spit on the floor. He would start trying to pull up the carpet. Teachers were not allowed to lay a hand on him. And so then he would get this intense sense of power and just walk out of the room, and they couldn't physically stop him. And he would go into the bathroom and start shoving giant wads of toilet paper down the toilet. The only thing teachers could do was call my spouse, get her to leave work and come, and she had to physically pick him up just to make him stop. And it's just silly that that was how it had to be, but no teacher, he wasn't threatening any other children, so that's probably still the best course of action. But I also kind of wanted, as a mom at the time, to be able to say, just scoop him up. He weighs 70 pounds. So sometimes there are moments when teachers just feel like I can't do anything, and if I do something reasonable, I could get sued. And I think that's where this bill does offer some peace of mind. Page 6, Roman numeral 4. I appreciate that it mentions that students can be excluded from district-sponsored activities if they've had certain disciplinary actions, because right now, a lot of that is under the Wyoming High School Sports Association rules, and they're very clear on what grades a student needs to be eligible. And it turns into a very big local fight if a principal tries to say, sure, you're passing all your classes, but you were suspended last week for punching a kid in the face, so you can't, whatever. I think this needs to be able to supersede eligibility rules, and those don't often deal with behavior and how participating in activities is a privilege and not a right. The planning period, I agree, is a little bit random in here. But it's something I've mentioned as a teacher. It came about more when there was a teacher rights bill. I know there's a lot of issues that we haven't been able to solve when it comes to recalibration as far as teacher salaries and staying competitive and even keeping people in the teaching industry. I would say for most teachers, it all comes down to time. Like, sure, you can't pay me more, but what makes my job hard is I don't have the time to do all the things I need. If managing extreme behavior in appropriate ways is a part of our job, then it would make sense to me that this kind of goes along with that. Give me time in my day to de-escalate with a child or to learn how to better deal with it next time. It would be even better, rather than saying one planning period, to mention that a certain percentage of each teacher's daily schedule should be devoted to planning time. In 17 years, I've gone from teaching 5 periods a day with one planning period of about an hour. Then we were asked to do 6 periods a day, and our planning was put to 50 minutes. Then we're at 7 periods. Okay, but it's okay because you'll get 2 planning periods now. We're currently at an 8-period day with a 1 planning period. So it just always feels like we're hanging on by our fingernails just to be good teachers. So while it seems random, it is somewhat related to, if I'm always stressed to the max and hanging on by my fingernails, I'm not going to react the most appropriately in extremely potentially violent situations. So that is a part of it, as I would see. I wanted to reiterate what Mr. Farmer said. Graduation fines are sometimes the very last thing we can hold students accountable for, which is something they need to learn before they go into the real world. Students will break their computer, they'll get a new one, they'll break that one, they'll completely not take care of their stuff. And there's really nothing the school district can do. That is like the one last thing. If a kid has been not taking care of things and not turning things in for the past 4 years, that's our one tiny little tooth that we still have. Obviously, most kids, if they came to us and said, I just can't financially do this, they would work with the school. But that's an adult skill that we should learn, we should teach them before they leave, that if you've racked up a bunch of fines, you need to deal with that. You can't just ignore it. That's not how life works. And there's 18, so that's time for them to learn that. I'm very close. Oh, page 3, line 8, talking about, you know, who could intervene in the case of student safety. And would that cover bus drivers and to and from and transportation? It's worth thinking about the liability that's teachers who are oftentimes coaches, and you're taking kids on overnights and watching them in the hotel, and the amount of, you know, it's hard to find teachers who want to coach for a long time because the liability is intense. You lay awake at night worrying which kids are sneaking out to the floor below because they know the boys team is down there. And am I going to be personally sued if that kid gets out of their hotel room and it goes home, you know, is pregnant 3 months later? These are all the kind of things that run through my head as a teacher and a coach, and I've never known how that would play out legally. So this bill starts to give me some peace of mind, especially if it, you know, mentioned anytime you're being supervised by a coach during an activity. Parent notification. I'm also a parent. I think if my child were physically removed from a classroom for violence, I would want to know by the end of that day. That's not always possible because obviously if another child is trying to kill themselves in the bathroom and the ambulance is there and the principal's dealing with that, you know, most reasonable parents would understand that. But I don't think it would be ridiculous to have a state statute say that if a child is physically moved from a room, the parent needs to be notified within 24 hours. But it would be better before the child returns to school for the parents to know. I want to return to Representative Lawley's point about how do we make teachers feel safe? And I don't need the right to dictate, no, that child can never come back to my classroom. I have to give permission first. But I would like the right to say that the child cannot, if they were removed for violence, they can't return to my classroom without consent from me. And if I disagree with how the consequences were laid out, I have the right to appeal and the right to a formal mediation between me and the child. We don't want the child to not get to go to school anymore, but clearly there's something that's creating an unsafe place for either the child or me or the students or both. And that needs to be addressed. When that would be addressed, well, maybe that's why the planning period stays in the bill. As it sits now, you know, we're a small district. We do have an alternative school, but when I worked in Big Piney, we didn't. So if a student was too unsafe to remain in school, they were put on what was called homebound. So and this was before virtual was really a thing. You know, they had textbooks at home. There was a teacher in charge of emailing them what their assignments were. It's not a successful way for a child to receive an education, especially a child with behavioral problems. But it was an opportunity that was offered to the child to continue to learn. So that's sort of always been a possibility. There's more possibilities now that virtual is more of a thing. My question would be, if a child is deemed by this bill to be too unsafe to return to physically to their school district, well, some school districts don't offer a virtual option. Other school districts only offer virtual options. So would, say, my district have to allow that student a virtual pathway in this district? Or could the solution be you'll have to enroll in Weston County Virtual School District, you know? And if that's the case, that they would have to accept the student mid-semester, because when I've tried to move a student virtually just for parents' choices in the middle of the semester, any virtual schools I've talked to have said, oh, we're not enrolling right now, which is always strange to me, because as a public school, you know, if we had 20 kids show up tomorrow to enroll, we wouldn't get to tell them we're not taking any students right now. Again, I apologize if it's not totally in order. Reporting, accountability, transparency. I think that all sounds fantastic. The stuff is getting reported. What's tricky is it's different. Every principal you get, every building you work in, one year they want you to put it on an Excel spreadsheet. One year they want you to send a message through email. One year they want it in a PowerSchool entry. all that data exists somewhere at some point, but it changes every year where it's collected, how it's collected, and what's done with it. And just to reiterate, as a teacher, we are often left wondering, whatever happened to that kid who just cussed me out in front of my entire class? Did he get any consequences? I have no idea. But now I have to try and teach him and hope he doesn't undermine everything I say to the rest of the class for the rest of the school year. So I think teachers do have a right to know what consequences are being played out. And we don't need ultimate decision over what happens for punishment or consequences for the child, but we need input, and we need a right to an appeal and a right to some remediation if we disagree. Let's see. I think I'm almost done. Oh, just the last point on building leader accountability. I do think that is a huge part of the problem. Your building principal makes all the difference in how safe and supported you feel as a teacher. Sometimes you feel very safe and supported, but what this bill does, like I said, is helps me know that if it comes to a legal battle between me and parents, or the principal and parents, that there is some legal grounds for the decisions that the school made, whether it was taking a kid's cell phone or tackling a child because he was beating someone in the face. Barring someone being unsafe to themselves or others, I don't think school district personnel should be able to lay hands on children. But if there's an issue of safety, I think anyone in charge of supervision of students needs to have that right. I don't want to feel powerless as a teacher in a moment of chaos. I don't want, my principal has assured us that if someone's walking through here with a gun and we tackle that person and they end up hitting their head and dying, he will go to bat that we made the right choice. But just because he's on my side doesn't mean that I am necessarily protected legally. And so those are things that we have to talk about in staff meetings all the time that are very scary. I myself have thought about being a principal for years and years and years, and I keep coming back to what was said. I want to be a principal because I want to teach teachers how to teach better. But I know it would all come down to being logistics and a disciplinarian. So, and again, with the recalibration, districts have spent the last 15 years trying to stay competitive against other states so that we have quality teachers. That means we've eliminated vice principal positions, which used to take most of the disciplinarian issues. That means we had an SRO last year who was spread out between Sublette County. She had 9 schools over 5,000 square miles. She only made it through 2 years of that before she was too burnt out to continue. So it's a leadership problem. It needs to also be tackled. Perhaps there's somewhere in this bill for that. I know the superintendent Megan Degenfelder, when we brought that up to her as a teacher group a couple of years ago, she created some optional classes for building leadership. And we all felt immediately that if it's optional, the ones who need it the most aren't going to be taking it. But I would like to see some building level accountability in here as well. But for the most part, our principals are good. They have our back, but we don't know if the legal system has our back. And that's scary sometimes. And with that, I stand and yield for questions.
Questions? Is it Miss Howard? Is that correct? Did I get the right last
Mrs.
name?
Adam.
Adam. Okay, I wasn't close at all. Any questions at all?
Mrs. Howard
Questions
is
on-
the other one from Pinedale.
Okay, maybe that's
You're
where I
not
was
totally
getting
off.
at. Yeah, okay. Yes, Representative Lawley.
Thank you, Madam Chairman. Again, thank you for being here and your comments. I really appreciate in particular that you spoke both as a teacher and a parent, because I think that's really helpful. And you kind of can do it in a more balanced way because you are a teacher and you know all the things that go on in these processes that, need parental involvement, but as a parent, you want to be involved. So I just appreciate those comments. I think they were very helpful.
Any other questions? Okay, seeing none, thank you for taking the time, since you don't really have a lot of time, but thank you for taking the time to give us your perspective. And I agree with Representative Lawley. It's always great to have someone that's been on both sides of the deal. With that, if there's no other public testimony, anything else online, Ashley?
No, Madam Chairman.
Okay, anyone else in the room? Okay, we'll go ahead and close public testimony. I had a feeling when I said this, we're going to be able to get going here and get a little, I knew that was a kiss of death. Yeah. So anyway, it is 12:12. What I think, this is just my suggestion. I think this is a really important bill, and maybe we can make it be better. Maybe there's not consensus on whether we should move it forward, but I would like everyone to just maybe take their lunch hour and think about it. Think about, this is probably the number one issue that we've been asked to try to help teachers with, and see how you feel about it. And we can put it off until after we come back from lunch, and you can decide then if you think we can fix it, make it better, move it forward, and so on and so forth. Does that seem okay with everyone on the district? Yeah. Representative? No? You just wait. I thought you were just, okay. If that's all right with everyone, we'll go ahead and take a lunch break. We'll meet back at 1:30, and then we'll take some action on this last bill. With that, we'll see you back at 1:30. Thank you.